আমার ইনজাংশনটা না থাকলে প্রবলেম আছে। My lord.
Yes.
Lord,
Yes,
may
from
I-
the right to the left. Yes.
May I seek my lord's leave to mention one matter in monthly list item number 436. My lord, the urgency of the matter pertains to, my lord, from 2013, I am entitled to a higher scale of pay for acquiring higher, my lord, educational qualification. On the same issue, your lordship has passed an order on 21st April 2023. Same line of judgment should be
Give the
passed.
attach the order with the mentioning slip
Very well.
and
Very well.
give the mentioning slip.
Deeply obliged.
Write your urgency, attach the
Yes,
order.
I have
to
written the
mentioning
urgency.
slip and
Deeply obliged.
Mr. Banerjee.
My lord, may I have my lord can leave, my lord, to mention item number 47 and 48. I have just handed over the copy of the order. My lord, the assurance was obtained by the honorable court from the learned advocate for the writ petitioners that they will not, he will not proceed with the contempt matters till 11th of May. The contempt matters have been fixed on 15th. Today, it is in such a position, my lord, there is no likelihood of taking up the matter in the first half at least, because I have the mentioned matters are up to 115. So, my lord, in the event it doesn't reach today,
What
My
are what are the item numbers?
item number 47 and 48, but I have handed over the copy of the order. Only one copy, my lord, it was there with me.
Contempt is fixed on
15th of May.
who appears for the other side.
Mr. Joyanto Mitru, not the senior Joyanto Mitru, my lord. But my lord may remember, my lord was already passed an order. At that juncture, he entered, my lord, and then this order was changed.
Very well. Let the matter appear as to be mentioned tomorrow. 15th of May.
15th of May, my lord.
To be mentioned. Will the assurance was given by the council for
Yes, my lord, initially, my lords were pleased to pass an order.
and
It
what
was
about the,
dictated. At that juncture, my lord, he entered. But after taking breath, my lord, since he appeared, my lord was pleased to ask him that.
so on the 15th of May, who has fixed the contempt? Your mentioning is over. may
It has been
You
fixed
can
by.
attend to your other business in court.
My lord, only one thing, subject to your lordship's convenience, my lord, if the matter could be taken up on Monday, subject to your lordship's
That
convenience.
is all. You can now attend to your other business. We have to take it up.
Very
My lord,
Yes.
my lord Justice Kaushik Chandu, my lord.
No, that is, has his lordship fixed the matter on
Yes,
15th?
because on the basis of this order, my lord, the matter was called on, then it was, my lord, fixed on 15th.
To be mentioned tomorrow. Give a notice to
I'm trying, my lord, I shall give, even if not possible, through WhatsApp, my lord, because it
whatever it is, try to inform him the matter will appear tomorrow.
Yes, yes.
Has to be mentioned.
Yes.
Give notice to, ask your advocate on record to give a notice to the respondents for tomorrow.
I'm trying, my lord.
Yes.
My lord, I am appearing in parcel. I want to file one MAT for leave without a certified copy.
You appeared in
Without a server copy, and similar case is being listed tomorrow. So if my MAT is hard together, my prayer.
You take the leave for now, then we will see. Take the leave.
Your
Leave
Lordship,
the-
Obliged, ma'am.
the same order, Your Lordship, this appeal is from, on behalf of Union of India. I'm seeking leave to file the appeal without the certified copy. Your Lordship, two appeals have been fixed tomorrow. It was mentioned by Mr. Lakhi Kumar Gupta, Your Lordship. If all the matters could be heard together, Your Lordship.
The EZCC matter.
EZCC, Your Lordship.
You give the, you give your slip.
Your Lordship.
May I submit?
Have you filed your appeal?
Your Lordship, I'm seeking leave to file without certified copy.
take the
After,
leave.
once it is filed, I'll give the.
Give the number, similar with you, give the number and write EZCC in both these slips of paper.
May I obtain leave, my lord, to file a memo of appeal without certified copy, my lord?
Yes.
My lord, may I have your lord?
When was the order passed, Mr.?
23rd March 2023. I have applied my 24th, my lord. I applied, my lord.
Give it.
My lord, may I have your lordship's leave to mention an urgent matter, my lord? Actually, I have got a letter from the authority that my appointment will be cancelled by 16th, my lord. So,
On basis of what?
my lord, it is
চিঠিটা
actually,
সাহেবকে দেখান।
Ah.
On the basis of what has the letter been given to you?
my lord, actually, the single bench has dismissed my protection of pay order. So, after that, I have intimated them that I have sent them the copy of the stay application.
Where is the order of the single bench?
That is with the appeal, my lord.
You have to annex the order with this mentioning slip.
My lord, here, my lord, in the letter, they have clearly mentioned everything, my lord.
That is that you depend on the letter. We are not taking ultimate responsibility. If
But-
you insist on this, এই চিঠিটা রেখে দিন, এটা থেকে যা বোঝা যাবে, না বোঝা যাবে, না বোঝা যাবে। উনি বিকেলে, thank you for that. All that we were requesting you, this is their letter. Number one. Number two, there is an order of the Honorable Single Bench which decided against you. So we need that order. Number three, you have to
Well,
write
Just within few minutes, my lord, I will hand over.
Number three, you have not completed number three. Number three, you have to take a piece of paper, write your urgency there in the context
I have written that, my lord, in my mentioning.
Take you a few minutes, attach the order of the single bench and give these complete paper.
My lord, just now I am bringing.
You have time till lunchtime. That's not a problem. Take your time and give it to our court officer. Yes, Mr. Biswas.
Lordship, kind leave to mention, my lord, one appeal. My lord, your lordship, my lord, set aside the one, my lord, clause, my lord, in the advertisement of the West Bengal Board of Primary Education, my lord. Now they moved the writ petition, my lord. My lord, initially they applied as DLED candidate. Now, my lord, they want to be applied as B.Ed candidate. The single bench directed us to, my lord, open a portal. My lord, it amounts to, my lord, initiate a new, my lord, the recruitment process, my lord. I am seeking your lordship's leave, my lord, to kindly, my lord, list the matter, my lord. Otherwise, my lord, we have to face this, my lord.
What was your stand before the single bench? Did you show the division bench order?
Yes, my lord, we have shown the, my lord, the order of your lordships, my lord, the
Yeah.
division bench, and my lord, we have stated that now, my lord, it is impossible for the board to, my lord, open the portal. My lord, it amounts to, my lord, initiate a new process, my lord, the
That
recruitment.
is one part of the issue. The second part is that there are recruitment rules.
My lord.
2016.
My lord,
Those recruitment rules show that this qualification NCT imposed, what we
My
recall
lord.
of the judge,
my lord,
has to be possessed by a candidate on a cutoff date.
my lord,
So your advertisement cannot go beyond the
My lord.
regulations.
my
Have
lord,
you shown that to the single bench?
my lord.
What is the approach?
What is their contention is they have acquired the B.Ed degree before cutoff date, but they didn't apply as B.Ed candidate. They applied as D.Ed candidate, took chance. My lord, now, my lord, after setting aside the, my lord, clause 3, now they are, my lord, trying to, my lord, invoke and, my lord, as a B.Ed candidate. My lord, this is not permanent. This is also, my lord, my lord, change of game after, my lord, the advertisement, my lord.
That stand, unfortunately, the board should have taken the hearing before us also. But anyway, we are only with the point of view that your advertisement cannot travel beyond the recruitment regulations.
My lord.
So if your recruitment regulations are amended, we have nothing to do, but they are not amended. They
My
are as, please give it.
My lord, I'm deeply obliged, my lord. Grateful, my lord. No, bolo.
Appear as to be mentioned.
My lord, I'm deeply obliged.
Please give notice to the
My lord,
officer.
I'm my lord.
সোমবার বা বুধবার। Court officer, when does it appear as to be mentioned?
My lord, I'm giving the notice, my lord. Yes, my lord.
Vimal. Junior to the court officer.
My lord,
Find out
I will,
the
my
date.
lord.
Sir, we have also prepared an appeal on same.
Give the, at দুটো একসাথে attach করো, staple করো।
Grateful.
Please provide the order of the honorable single bench in the, as the server copy.
My lord, I'm
Please
giving, my lord.
provide the order and give it to him.
My lord, I'm giving.
Those two slips will be together and the order of the single bench will be attached.
My lord, I'm giving, my lord. I'm giving.
Order. My lord, minor correction is there.
We cannot follow you. Please speak on the microphone.
My lord has passed an order, 13th April. Minor correction is there.
Yes.
Previously, I have mentioned, my lord.
To be mentioned there. Ekhuni note kore now, correction. Mr. Mahato,
Yesterday I mentioned, my lord, the urgency is, my lord, on 1st May, my lord disposed of the matter. My lord, since the order, date of order is, my lord, wrong. Instead of, my lord, 20th August, it has been written as 5th August. But the university has been directed to comply within a 1 week. But, my lord, he is not doing this because of this correction. My lord, let it appear tomorrow, my lord.
yes, to be mentioned tomorrow.
I have
এটা
also
tomorrow
annexed.
to be mentioned. কালকে এটা to be mentioned আছে না?
খোঁজা দেখাচ্ছে। I have also given the order.
Yes,
I have also annexed.
Taijul Babu, এখানে 47, 48.
Subject to the leave of the court. In fact, item number 43 of the Lordship's days list. Where I being a senior citizen, having age above 72 years, and I am deprived of my regular pension. Matter is pending. Lordship kindly heard the matter. My lord.
It is appearing as mentioned matter.
Mentioned matter.
Let us try. Let us see. Give the slip with the copy of the order impure. Item 43.
Item 40.
Give the slip. Let us, my lord, his lordship will
I'm
go
handing.
through.
Lordship, may I be permitted
Yes,
to
Mr.
mention?
Banerjee, from left to right now. Yes, madam.
My lord, today's item number, today's is item number 2, my lord. There is a Honorable Justice Vishwadit Basu pass an order, my lord, that enter selection process is monitored by division bench. Petitioner seeks for further hearing, my lord. So, this kindly tag this matter with this appeal, my lord.
When the matter is called, kindly be present in court. We will try. Item 2 today
Yes, my lord.
please
Today
wait.
fixed 2 p.m., my lord.
at 2 p.m.
Yes, my lord.
Please wait. Come back at 2 p.m. When the matter is called, then you raise your point.
Yes, my lord.
When the matter is called, either today, tomorrow, you please come at that point and raise your point then.
Grateful, my lord.
Yes, Mr. Banerjee.
My lord, the appellant's approved service has been terminated by the BDO, rehearsing the law, my lord, rule, my lord. And my lord, the single bench affirmed the order of the BDO, my lord. My lord, I am not
BDO.
getting any since 2019, my lord. And in my place, my lord, by virtue of single bench order, the private respondent has been substituted. And what his service is not approved, my approved service has been in.
Give the slip.
I have given the grateful.
My lord, may I permitted to mention a matter? My lord, I was working as ASHA worker in Murshidabad district. After clearing the selection process, after 4.5 years, I got a termination letter. Then I found that I was made a party in a case, but no service copy or something came to me. I was unaware of that case. Later, I got terminated. Now I am in financial crisis. So my lord, I am challenging the order and obliged, my lord.
You have to file an application for leave to appeal. Since you were not a party in the before the single bench.
Yes, my lord, I was party, but nothing came to me. No service.
Give the slip. Give the
My lord.
slip. Give the slip and attach the order of the single bench.
My lord.
You have a server copy. Attach the order
Yes, my
of
lord.
the single.
I am
No,
giving.
then you give it in course of this.
Lordship,
Yes.
may be permitted to mention on matter for inclusion as mentioned matter.
Yes.
The respondents are, they have retired from the service from 2009 to 2017, but their retirement dues were yet to disburse from till August 2021. They are yet to get their arrear pension, Lordship.
Attach the order of the honorable single bench.
Okay, yes.
Then-
May I permitted to mention one matter, my lord?
Yes.
Yeah, I was working as assistant teacher under Ramakrishna Mission. I took maternity leave for 3 months. When I went to join the school, They refused to join, challenging that order. I came to the learned single bench. Learned single bench said that the writ is not maintainable as the Ramakrishna mission is not amenable to jurisdiction.
Attach the order, give the slip. Mr. Islam,
Yes, my Your Lordship. This is, I'm mentioning this matter. This matter is running as item number 277 on first May list. Your Lordship, this matter has been dismissed for default. I'm praying some upgradation for the recalling of that order, Your Lordship.
277 it is on. What
On
about
the
it?
first of May.
You have an application, you filed an application.
Yes, it is there. The application is there, Your Lordship.
So you, as of now, you want a restoration,
Yes, Your Lordship.
nothing more than that.
No, nothing more than
Have
that.
you
At the
served
present
copies
moment.
on the other side?
No, I have not, Your
You
Lordship.
have to serve the copies of the application you have
As
filed.
Your Lordship directs me.
Yes, and then it will appear as to be mentioned next week.
Oh,
But only for the purpose of restoration,
Only for the
provided
purpose of
sufficient.
restoration.
When was it dismissed?
It was dismissed, but it was dismissed on 1/7/2021. Unfortunately,
And when did you file the application?
I filed this application just a second. In 11th day of July 2022.
You give it, you give the slip. We'll
Yes, Your Lordship. Grateful.
Thank you.
Lord, I'm led by Mr. Kushman.
My lord, I am appearing for response number 22, Chief Labour Commission. And I am appearing for Coal India Limited.
With leave of my learned senior Millard. There's an order, Millard, from an interim order, Millard.
This matter,
Millard, may I just say, Millard, to senior name?
this matter, Bikash Ranjan sir is appearing. He went to the Supreme Court for yesterday. Kindly fix the matter tomorrow or day after
Let
tomorrow.
us see. Let us see the order.
Look at the order, Millard.
Yes, let us see the order first.
Kindly look at the order, Millard, internal page 2. Sir, apni bolna na bolna. I bol. No, with leave of my senior Millard.
Who is your senior? Mr. Ghosh.
He's permitted
You're appearing.
with him. Millard.
Who is appearing for Coal India?
I am appearing.
You're appearing for the writ petitioners.
Yes, I am
I
for
am
the
appearing
ECL.
on the
You're for the union.
Respondent number 22, Chief Labour Commissioner.
Let us read the order first.
Millard, kindly have a look at the order. Millard, it's from an interim order in a writ petition, Millard, which was filed in 2015. May I just place the order, Millard? In this matter, I appointed one special officer. There was
Yeah, we'll read it let us read it at our own pace.
yes, no difficulty, Millard.
And there's no kindness in reading an order. It's our job. It's an appeal court, so we have to read the order.
Millard, I know.
Please take your seat. We'll read the order. Come back. Yes.
Milord, writ petition initially moved, no interim order. Thereafter, coordinate bench, Milord, opined that the matter has to be thrashed out on affidavit. Why, Milord? Because, Milord, employer-employee relationship has to be established. Thereafter, only, Milord, the payment of salary comes, Milord. Now, Milord, there was no, Milord, connected application. Special officer appointed, showing a letter. Milord, there was no connected application, Milord, for Milord deposit of money in court. No prayer. This prayer is beyond the scope of the writ petition, Milord. I'll show the prayers. This is completely beyond the scope of writ petition. And I was not heard, Milord, basically. Can you look at the order? In this regard, I direct the chairman come managing director, Eastern Coalfields Limited, to deposit a sum of rupees 6 lakhs with the Register General of this court. So the situation, if the situation arises, the payment for some months can be made to the teachers and non-teaching staffs from the school from the deposit. This deposit will be without prejudice to the rights and contention.
But your schools are
Not my school. It's a school of the private managing committee. Private managing committee. Unaffiliated school, Milord, there is no affiliation.
And why are you drawn into the
And
picture?
most are in Jharkhand, and Milord, mostly in Jharkhand, and the school were not operating. There is a report.
That is not the, who is the special officer?
Milord, the special officer, Milord, Pradeep Kumar Ghosh. Milord, there was no prayer. Milord, fundamental is there should be a prayer. Milord, the fundamental is, Milord, writ petition, there should be a prayer. Where is the prayer, Milord? Milord, kindly have a look. And one of the writ petition, his
We want to have a look at the special officer's report and also hear the special officer.
It is annexed.
It is annexed. It is annexed. Lordship will kindly have a look at, Milord, the special officer's report, Milord. That's annexed.
Page 159.
Kindly have a look at page 159, Milord. Kindly have a look at it, Milord. This appointment is also, Milord, without there being an application. Kindly have a report, Milord. The solemn order dated such and such passed by Justice such and such passed in WP number 7708 of 2011 along with WPWA number 7995 of 2016. This 7995 2016, Milord, has been dismissed for default. Not restored. Milord, this has not been restored. An order is passed on a dismissed application. I was appointed as special officer to conduct surprise visits of the school in the name of the writ petition to record of the school such and such. Now, Milord, kindly have a look at.
We'll read the order.
Yes,
please.
kindly have a look at page. Kindly, Milord, takes Milord page from 162 onwards. Kindly have a look at from page 162 onwards, Milord. Then, Milord, kindly take Milord para 8 at 163.
We are reading it one by one, please, and please bear with us.
উপরে বসেছে এই উপরে বসেছে
Please take your seat.
Granting.
Yes.
Now, Millard,
You-
most
we-
important,
which-
Millard, 3 points, Millard, I'll want to place, Millard. Millard, kindly make a note of it. In the writ petition, Millard, there is a prayer, Millard, for establishment of a employer-employee relationship. Specific prayer. It presupposes, Millard, there is no employer-employer relationship, and unless it is, Millard, done so, Millard, no order in this nature could have been passed. Point number 2. And Millard, point number 2.
How did the schools come to be set up?
Millard, this school where ECL is giving granting aid only to this school, granting aid. These are Millard, one of CSR scheme, Millard. I'll place that. CSR scheme 3 is on record. 9 I am carrying with me, Millard. Now, Millard, in the meantime, Millard, there's a procedure, rules how appointment can be given, Millard. Now, Millard, these schools, Millard, are granting aid is provided by ECL, merely granting aid, nothing more, nothing less. There's a managing committee, private managing
In
committee.
which year did you give the grant in aid?
Millard, it's going on from 1984.
What is your grant in aid audit report? How much when did you last pay a grant?
Millard, last Millard, it's Millard paid. I'll show that, Millard.
To show that.
Yes, Millard, granting aid was given. Now, Millard, admitted position, Millard. This writ petition, this has to be established, Millard. Kindly look at the prayer, Millard. Kindly look at page 38, Millard, of the stay application, Millard. Kindly take page 38 of the writ petition. Kindly have a look at that. This has to be thrashed out on affidavits. In fact, Millard, one of the coordinated benches say so in this writ petition itself. Kindly have a look at, Millard, page 38, paragraph 5.
When were these schools established?
1984. Most of them are in Jharkhand. First of all, there's the issue of territorial jurisdiction.
And they have been functioning from 1984 onwards.
84, only granting aid.
Correct.
So, Millard,
So
they,
when was-
Millard,
Do you have a statement of what were the annual grants in aid?
Millard, Millard, don't have it in the Millard petition, but Millard, the orders of granting aids are all annexed, Millard, to my affidavit. My affidavit has been affirmed in 2017. Millard, in all fairness, Millard, the matter has to be heard out, Millard, finally. Millard,
Show us which page you want to show.
yes, kindly, Millard, have, Millard, 2 things. Millard, first, Millard, this is prayer. Second, Millard, the writ petition is a composite writ petition in respect of which one of the writ petition is already dismissed for default. Kindly have a look at page 176. Restoration 176 of the stay application. The matter is dismissed for default. So, Millard, admittedly, Millard, there is no list.
Which writ petition?
Millard, writ petition number 7995 of 2016, Ishwari Lal and Eastern Coalfields. 1 is, Millard, remaining. So, Millard, admittedly, there is no list, Millard, to such effect. Now, Lordship will kindly have a look. Kindly now, Millard, have a look at page, Millard, 179, the coordinate bench order in respect of this writ petition itself. Because I'll show the prayers then, Millard. The issues involved in the writ petition is required to be examined in affidavits. Page 179, Lordship. I'm sorry.
Yes, yes.
The issues involved in the writ petition is required to be examined by affidavits. The court directs the learned advocate of ECL to file a detailed affidavit in opposition on the basis of the records maintained by the management of the respondents within a period of 4 weeks. Reply to be filed. Now, Millard, it is kindly next second last paragraph. It is submitted by learned advocate for the petitioner that after filing of the writ petition, the ECL has now paying the salary of the teaching and the non-teaching staff. The learned advocate for the respondent opposes and such submission and submit that the salary is not being paid to them. It's simply an allegation made by the learned advocates for the petition.
Document, if
Yes,
we
yes,
may
I'm
ask.
giving to you, Lordship Millard. Kindly have a look, Millard. Kindly have a look at my affidavit in opposition, Millard, where I have stated so, Millard.
Vision document.
Millard, kindly have a look at Millard, page 98. This is part of my Millard affidavit in opposition filed in the trial court, which has not been taken on record, Millard, because the learned judge, Millard, I do not want to make any comment, Millard, but this is not taken on record, affirmed in 2017, Millard.
Page.
If Lordship takes the prayer once, as my Millard, learned senior Millard wants me to place, kindly have a look at the prayer. Page 63, have a look at the prayer. Millard, a writ in the nature of mandamus commanding the concerned respondent or treat the petitioners as the employee of the concerned respondent directly controlled by the respondent number 1, i.e. Eastern Coalfields, subsidiary of Coal India Limited, by setting aside and squashing the notice of action or impute action taken on the report dated such and such. Now, Millard, kindly take the last one. Now, kindly, a writ in the mandamus commanding the respondents to pay salary to the petitioner month by month for treating the petitioners as an employee of the Coal India Limited. So, Millard, it has been, Millard, altered. Millard, now, Millard, kindly of prayer C also is also, Millard, creation of direct employer-employee relationship. With Millard, none exists, Millard. Now, kindly now take, Millard, page, for my satisfaction, kindly have a look at my affidavit in opposition, Millard, page 98, Millard. Kindly have a look at page 98. Millard, it's June 17, 2002. Millard, association with of ECL executives, de-association of ECL executives from the managing committee of the private managed school, page 98. Millard, appended below is a letter dated such and such of the chief personal officer, subject noted above for your kind information. Now, Millard, kindly have a look at paragraph 3. In this connection, it has been decided by the competent authority that if there is any executive in the ACL as well as the managing committee of the private school managed by the school which received current grant from ACL, this should be discontinued and withdrawn from the managing committee of the school. Henceforth, the following procedure would be maintained to release the grant in aid of the school. So, Millard, the admitted position is, Millard, the grant in aid, Millard, was given, and the ECL, Millard, executive has been disassociated from the managing committee from the year 2002. Presently, it is run, Millard, the cutoff date is the date of filing of the writ petition by the private bodies. ECL is not connected. Next, the general manager committee, the principal headmaster may be advised to constitute a managing committee, and our resolution is to be adopted and also open a separate bank account relating to the withdrawal from there. The general committee of the private committee managed by the managing committee charging tuition fees, school managing committee should ensure proper utilization of the granting aid. Now, Millard, kindly have the next one. It may be noted from the jaw onwards that the granting aid in such school will be given for utilization certificate received from the previous year, and the constituted committee of the respective school duly signed, authenticated by the competent authority. The above instruction and committee should be followed strictly. So this is the first document. So this is an issue happening in 2002.
You have we are asking you, we are maybe at this stage,
yes,
for the sake of argument, we are with you that the possibility of establishing a master servant relationship may not be there. But do you have an audit statement complete? Of
I don't have, kindly have the root document. Kindly have a root document. Millard, 13th March 1984, page 104. This is what we have done. And Millard, this issue, Millard, Lordship will correct me if I am wrong, is covered by the NALCO case. Now, my lord, kindly take my lord 13th of March 1984. Kindly have a look at it. Kindly, my lord, take my lord, just my lord after housing. It's document dated 13th March 1984. My lord, just after housing. This is part of my affidavit. Defrost will have to be made to ensure 40% standard houses. Lordship forget omits that. Education breakup of 100 school building of different standard constructed in replacement of some new during the period of the agreement. Now, Millard ECL in 1984, Millard is constructing 23 schools. As per this circular, now Lordship will kindly skip that for the time being. Now, Lordship will kindly take Millard 106 allocation. See, the allocation of additional amount of 2 crores per annum, Millard page 106, capital expenditure for subsidiary company of Coal India, etc., etc. Now, Millard kindly take Millard. The above allocation will be administered by the company joint was bipartite committee performed at an early age where the workers come forward with their own contribution for running an educational
So
institution.
what are you trying to prove?
Millard, I am trying to establish this is the 84 on the basis of some scheme of ECL. Millard.
Yes.
Granted aid was also given, Millard.
Yes.
Now, Millard, there is no employer-employee relationship.
Understood, accepted, taken.
Millard,
But
the writ is pending, Millard, final adjudication for Millard. The prayers to be passed on the final relief in the writ.
not necessarily. Anyway, we may not be in agreement with you.
Yes,
And if the
great.
6 lakhs rupees, how is it hurting you?
Not a
It-
question
you
of
take it,
hurting.
you take
First,
it,
Millard,
you take it as if it's a grant in aid.
Millard, Millard, first, Millard, there is no establishment. All Millard is no, first of all, there was no application. Kindly takes a note of it, Millard. There is no prayer, no application, and Millard, an order has been passed in 2020. Millard, the matter, Millard, affidavits are complete. It should be thrashed out on affidavits, Millard. The
I
matter,
Very well. Any other point?
yes, Millard, kindly, Millard. These are unaffiliated school. The school doesn't have any affiliation, Millard.
Yes.
Millard, kindly, Millard takes 185. Kindly have a look at 185. This is Millard, order passed, taking Millard, review Millard, that it is sacrosanct, the statement. The contention of the petitioner is that they should be treated as an employee of the respondent number 1, and the said respondent should pay the salary of the petitioner month by month. It is the contention. The advocate of the respondents has appeared today. At the very beginning, Mr. Such and Such, learned senior advocate, has handed me a copy of the letter of Eastern Coalfields signed by the general manager, dated such and such, which is Millard quoted. I just place it, so I don't place the letter. This has reference to your point number 60, such and such of the minutes of the meeting dated such and such, wherein ECL has observed under 19 school under the grant were found to be non-existent practically, therefore payment must be avoided to such school. Now, Millard, there was a vigilance. These schools were not functioning. On the vigilance, Millard, it was observed, Millard, but the committee, Millard, that the grant should be stopped. Now, Millard, kindly take, unquote, enclose the list of 19 school privately committee managed, which were found to be non-functional during the joint inspection by the vigilance department. This is for your kind permission. Other action, please. Mr. Such and Such has submitted that during the school hours on no such joint inspection of vigilance department, the area officers were made. The teachers of the sum whom are present today before the court are teaching in the school and submits that there is a wholly incorrect to suggest that the school are practically non-existent practically. Therefore, I appoint Mr. Such and Such as a special officer. Now, Millard kindly takes the audit report.
See what?
Kindly take page 145 is the letter on the basis of which the order is passed. This is not part of the writ petition. This was shown to the court and an order has been passed. Kindly take page 145, 20th of March, 20th of January 2023, page 145. 19 schools under the granting aid were found to be practically non-existent practically, therefore payment should be avoided to the school. Now, Millard, kindly now have a look at page 148. Lordship had asked me the question. I should have pointed this out, Millard, first. Millard, 148, Millard, it's there. Now kindly take, Millard, the list of school. There was a thorough audit in the area, Millard. Kindly take 149. List of school where payment granted needs to be reviewed. These are the 19 school. And Millard, mostly Lordship will find, I have given Millard. 8 and 9 are Millard upper primary school. Rest are primary school. There is no affiliation to such school. And serial number 2, Adarsh Middle School, Kudia. No students were present. Building condition extremely poor. Surrounding very dirty. No student. Now, Millard, kindly take 4. No student. Now, Millard, 6 Horizon Primary School, 5 students. So, Millard, there is a detailed report by the ECL, Millard. So, Millard, in detail, Millard, this is Millard given, Millard. And Millard, an order, Millard, thereafter, Millard, the learned judge wants to himself, Millard, inquire, and Millard appoints a special officer. There is no application on board. There is no application on board. Now, Millard, this issue, Millard, prior to Millard, passing any interim order is, Millard, covered, Millard, by the judgment of the Honorable Supreme Court, Millard. Millard, may I just place it, Millard? Same case, Millard, what would happen to a grantee network? Kindly, Millard, have a look at, Millard. May I just hand up, Millard? It's stitched on this side. Eta debe. Millard, kindly, Millard, have a look. Kindly take paragraph 2, Millard.
Paragraph
2. Millard, every Millard coal company in its Millard area, Millard, or Millard a national aluminium Millard previously, or Millard Kolaghat thermal station, Millard, have a school. But whether the teachers, Millard, will be, Millard, an employee of NALCO or ECL, Millard, and claim benefits, Millard, perimeter with them. This is, Millard, the issue. This is, Millard, reported in 2014-6 SCC 756.
Which paragraph are you like?
Kindly, Millard, takes Millard, para 2 first. What was the issue there? Issue there and issue here are the same. The writ petitions were filed by the employees of each of the school in Orissa High Court, Cuttack, for declaration that they are the employees of NALCO and be treated as consequential prayer. In this, employees are to be accorded suitable spares admissible to the employees of NALCO. Having regard to the commonality of the fact situation under the writ petitions were filed, and as well as the similarity of the issue in both writ petitions were heard by the High Court, outcome of the judgment dated such and such. The High Court has accepted the case of these employees of SB, holding them to be the employees of NALCO. Another security decision of issued to make them available the benefits which are enjoyed by the employees of the NALCO present in the appeal. The question of validity aforesaid judgment of the High Court. Now, Lordship will kindly take, Millard. I'll just, Millard, skip, Millard. Kindly have a look at Mr. Rao's judgment. Kindly have a look at paragraph 21. Millard, 17 and 18 is the argument of Mr. P.P. Rao, Millard, which is, Millard, I adopt the argument of Mr. Rao, Millard. His argument is paragraph 17 and 18. And Mr. Venugopal's argument is paragraph 20, which has been rejected by the Supreme Court. We have considered the aforesaid submission with reference to the record of the case. No doubt the school is established by NALCO. NALCO is also providing necessary infrastructure. It has also given adequate financial support inasmuch as the deficit after meeting the expenses from the tuition fees and other income received by the school is made by the NALCO. NALCO has also placed staff quarters at the disposal of the schools which are allotted to the employees of the school. The employees of the school are also accorded to some of the benefits like recreation club facilities. However, the poser is as whether these facilities are sufficient to make the staff of the schools the employee of NALCO. Next. In order to determine the existence of the employer-employee, the relationship and correct approach is to consider whether there is a complete control and supervision of NALCO. It has been held in this court in Chemical Works Limited, way back in 1956, the court emphasized the relationship of master and servant is a question of fact, and that depends upon existence of the power in the employer, not only in what he direct work the servant, but also in the manner which work is done. This is to be explained in formulating the principle. Now, we'll kindly take paragraph 23. It is also established from the documents on record that both schools have their own independent managing committee. Here also, Millard, it's Millard the same thing, because I have shown the document 2012 dissociated, Millard. These managing committees are registered under the Societies Registration Act. In the managing committee, which is not only recruit the teaching staffs and other staffs and appoint them, but the other decision in respect of the same service are also taken by the managing committee. These range from pay fixation of senior grant, leave, promotion, disciplinary service, and have been framed with certain condition provision. Delineating all necessary service conditions, various documents are produced to show appointment letters are issued by the managing committee, disciplinary action is taken by the managing committee, superannuation, etc. So now Lordship will kindly take paragraph 24. Merely because the school have been set up, Millard, this is Millard most important, Millard. Merely because the school has been set up by NALCO, or they have agreed to take care of the financial deficits for running the school, according to us, they are not conclusive factors. Such appeals have been considered by this court in various cases. In Reserve Bank of India, the question as to whether the workers of the canteen were established and even financed by RBI when the workers of RBI. Various canteens were set up by RBI which were being run through a cooperative society. They were established in the bank premises for benefit of the employee. The bank was reimbursed the change in incurring the various statutory license, even prior permission are required to be worked. Now, Millard, kindly take Millard the quotation para 10. The bank does not supervise or control the working of the canteens or supply the eatables of the employee. The employees are not under the obligation to purchase eatables from the canteens. There is no relationship of master and servant between the bank and the various person employed in the canteen. Aforesaid, the bank does not carry any trade or business in the canteens. The staff canteens are established only as a welfare measure. Similar demands made by staff company and employees and requests made to central government to refer the adjudication was rejected by the central government, and the successful challenge before the Calcutta High Court was unsuccessful. According to the bank, it has no statutory or the other obligation to run the canteen. It has no direct control or supervision of the employees in the canteen. It is to be taken any disciplinary action to direct against the canteen to a particular work. The disciplinary control of the person deployed in the canteen does not vest in the bank, not the bank can say any allocation of the work or the work which the work carried out by the employees, sanctioning the leave disbursement, maintenance, attendance register, all are done by the Implementation Society Canteen Committee of the Cooperative Society. Millard, kindly take para 26. This is a ratio. This is the ratio, Millard. In the present case, as pointed out above, the day-to-day supervision and control rests with the managing committee, and they are not party. And from the appointment till cessation of termination, the exercise which is undertaken by the High Court is in nature of piercing the veil and commencing a real control veils with NALCO. Though we come with the aspect little later, it is necessary to point out at this stage whether the arrangement contract is sham or camouflage, a disputed question of fact. In the present case, the writ petitions were filed. It is not a case of an industrial as raised before the employee. Now, Millard, kindly have a look at Millard. Paragraph 26, 28, Millard, kindly Millard, takes Millard. Nilgiri, Millard is stated, Millard, I am not Millard cited. Kindly take the Coal Millard Company's case, which is, I have it, Millard, if Lordship wants, I'll cite separately. This is Millard, S.C. Chandra versus State of Jharkhand. Similar issue, same to same. Bharat Coking Coal, it's CCL, another subsidiary, it's Bharat Coking Coal. More significant case, having close proximity, in the present case is one of the judgment of S.C. Chandra versus State of Jharkhand. In that case, Hindustan Copper Limited, the government India Enterprise has established school. Employees of the school claim that the real employer was HCL. Admitted facts where the schools were established by HCL with the object of benefiting the children and work of HCL. Even financial assistance was provided to the school. The school below, however, came to the conclusion that the only by giving financial assistance HCL, it does not become the employer and teach working staffs in the school. They were held to be the employees of the managing committee of the school. The part of discussion is set out. Millard, same Millard. We have heard the learned counsel for the parties and perused the records. The basic question before us is whether the writ of mandamus could be issued against the management of HCL. The learned single judge relying on the division bench in an identical matter pertaining to Bharat Cooking Co. Limited dismissed the writ petition of the appellant. The issue was examined in an analogous writ petition. In the aforesaid case, the issue was extensively considered as to whether the management of the school is a direct responsible HCL or not. After considering the matter in detail, the learned judge, relying on the aforesaid judgment, found that there is no relationship of master and servant with the teacher and the other staffs of the school with HCL, as the management of the school was done by the managing committee, though liberal financial grant was being made by the corporation. There has been no direct connection of the management of HCL with the management of the school, though various communications and impressions were sought to be given by the school is being run by the school, but in substance, HCL used to only provide financial assistance to the school.
Accepted. The proposition is accepted. Therefore, what is the relief that you claim from this court?
This interim order, could not have been granted because the final relief could not have been granted. Interim relief in aid of that cannot be granted. It's a well-established, principle of civil law, which is borrowed in the writ petition, This is where, I place, in fact, in a writ petition, Supreme Court is saying so, kindly have a look at, that authority.
That is a proposition, we understand. We'll
can the order, today be granted, when my affidavits have been, I come to court, kindly, appreciates us.
When will you finish? Because we have run out of time. When do we then hear you next and hear the others next? We have run out of time today. Because there were other preoccupations
6
in the morning.
lakhs, without application of anything, without hearing, 6 lakhs. Why, in a
You have made your submissions.
Yes.
The why we are supposed to answer. We may be wrong,
Yes.
or we may be right. You are supposed to say it is wrong.
Well,
So
I'm
you may have
saying
made
so.
your submissions.
This
You
is
cannot
my
ask the
submission.
question why repeatedly to us.
I'm sorry.
Why we'll understand why. We
Yes.
may not understand why. It's up to our limited wisdom that we will do what we can do best.
This is on a writ application without any application of prayer.
That's right. You're repeating yourself.
Yes.
We understand that. We understand the fallibility of the order. We also understand the competence of the order. Any fresh point that you have, Mr. Ghosh?
There's one judgment, where the Supreme Court said writ petition, unless there is a prayer, you can't grant a order in aid of that. If Lordship wants, I can cite that. If Lordship settle
We
law.
have run out of time. That is the only. So when do we hear you next? After we could have heard you after recess, but there is another bench after recess.
I leave it to you, Lordship. I have a leader, his convenience, let me ask.
Yes. When is the next date before the Honorable Single Bench?
Today at 2 p.m., I have to furnish a report whether the money has been paid or not, This is what I am submitting. Kindly look at the order, it's recorded that. Lordship can take it from me,
Ashok.
And deposit.
Limited will not run away in 6 lakhs.
Your Lordship,
Order was passed when?
2nd May.
2nd May. Today we are on?
Today, we are on 10th. 11th.
In the meantime, when did you take leave to file the appeal?
Monday. My senior was there, I was not.
Monday was 8th.
8th. 5th was a holiday. I drafted it, on the 5th. Monday it was moved.
Party /R represent. Yes, what do you want to say?
Milord, kindly see the order. It is passed the single bench. When the order passed, Milord, that time both the party present and they can oppose the appointment of the special officer. They raise no objection. Then special officer.
I think we have run out of time. That is.
Milord, kindly, special officer submit the report and they are actually file the exception. It is written the order sheet.
We have followed that.
It is not
এক মিনিট
বলো
beyond 2 p.m. we cannot. So that is one aspect. They have an urgency, the second aspect. The third aspect is at 2 p.m. the single bench is to hear the matter. Fourth aspect is your aspect. So out of the 4 aspects, you can only adjust.
Your Lordship.
Parties / are represented. We request you to make alternate arrangements, come back tomorrow at 10:30. Parties / are represented in the order named. It সাড়ে 10টায় ডাক হবে। Parties / are represented in the order of their names / names as printed above in the cause title. Full stop. Matter is heard on an urgent basis, keeping in mind the submission of the parties.
Your Lordship, it is possible to
On the microphone.
Is possible to fix the matter in the instead of the fix the matter. It is 11 p.m. 11 a.m.
No, 10:30. Parties / are represented in the order of their names / names as printed above in the cause title. Full stop. Full stop. This matter has been heard on an urgent basis, comma, citing CITING. On an urgent basis, as pleaded on behalf of the appellants / the Eastern Coalfields Limited. Full stop. It is submitted by the appellants that the matter is that the writ petition pending before the Honorable Single Bench is scheduled to be considered today at 2 p.m. Full stop. The order dated 2nd of May 2023 as passed in the writ petition being WPS 7708 of 2016 with another is under challenge in this appeal. Full stop para. Since the business of the court today could not permit the arguments to be continued, let the matter appear next. What time do you want? What time do you want tomorrow?
Tomorrow is your Lordship fixed.
Let the matter be placed for consideration tomorrow. That is the for the arguments for the arguments to be completed, as well as for necessary orders, under the heading fixed 10:30 a.m. Fixed 10:30 a.m. Full stop para. The parties are permitted to apprise the Honorable Single Bench of the pendency of this appeal and the order passed today. Yes, come back tomorrow.
Grateful, my lord. My lord, I am led by Mr.
Affidavit of service file be detailed with the
Grateful. I am led by Mr. আসেন তো কালকে স্যার
chamber.
Lord, I mentioned this matter, Lord, couple of times. My juniors also have mentioned it. Lord, this is an appeal filed by the Union of India. Lord, I am the writ petitioner. I succeeded, but I'll retire in the month of August. All my benefits, Lord, are Lord stuck because of the appeal. I took out a contempt, but not the single justice since the appeal is pending. Your Lordship, Lord, heard the Union of India one day. The matter is part heard. Lord, if the matter is part heard, Lord, not appearing in the list, may it appear, Lord, any day your Lordship's convenience. Lord, I am really, Lord, if I retire in the meantime, then Lord, everything would become infructuous. Lord, kindly have the Lord charity to consider the plight of the litigant, Lord, kindly.
To be mentioned next Thursday,
Madam, grateful, so grateful to Lordship. I shall issue notice upon the Union of India, Lord,
2 p.m. next Thursday.
2 p.m. next. I'm grateful to Lordship.
Hello, I beg to appear for the appellants, my lords. My lords were pleased enough to direct me to seek instructions from the authorities regarding the scope of employment at this present state and from the current date. And my lord, I have come back with some instructions, my lord. They are not written instructions. My lord, there is a predicament. I could not get a written instruction, my lord, but it will be processed, I have been told. My learned senior friend had made a prayer in his writ petition seeking re-examination of the son of the petitioner. He had some eyesight problem as per the last medical records held by the board. My learned friend had made his prayers that a re-examination to be conducted and that re-examination be done by some independent body. My lord, I have come back with the instruction. If it is done through the Apex Medical Board, that is from the organization, and it comes through, it goes through, then employment may be provided, my lord.
Mr. Ghosh.
My lord, here what happened, my lord, 2-4 PL I have made. Either my lord employment to the son or my lord MMCC. So one part has been allowed by the learned trial court, my lord. Here, my lord, is still, my lord, my client, my lord, son is, my lord, agreeable. So my learned friend is pressing, my lord, that if the son appeared before their medical board and if he is found, then he may be provided employment. So my lord, at this stage, my lord, let the examination be done by their board. I have no objection. And if my lord finally found that if it is not possible, then my lord will proceed for MMCC, my lord.
So you keep your point on MMCC alive.
Yes, because if finally employment is not provided, then automatically, my lord, I have to, my lord, choose for this option, my lord. That has already been allowed by the trial court, my lord.
Why should this court be dragged into so many uncertainties? We have a simple order. We have a plain and simple order of the single bench. We have to determine the correctness of the order. Now, after so much of argument, so many probabilities, why should we involve ourselves in it? Keep going. No, we are not getting into probabilities. Now, finally, what is the argument? Mr. Ghosh, your offer remains with ECL. ECL handles your offer. We have an order of the single bench. We have to decide on the merits of it. Will you tell us on merits anything more to be submitted, Mrs. Banerjee?
My lord, I came back with instructions as.
That's right. That instruction is understood. And now we are not on the merits of the order of the single bench. Any further submission? Or would you like to file a notice of argument and
My
complete?
lord,
Because we are not here to, we have to assemble after some intervals and we are all have
but
independent.
only one chance may be given, my lord, so that employment can be availed to the son of the petitioner. That is the intention, my lord. In this case, it is possible. It is possible. Let it be
Mrs.
considered as a,
Banerjee,
yes, my
one
lord.
thing we can do,
My
that
lord.
is, if you complete the screening and come up with an offer by the next date, adjourned date
Yes,
of your,
yes, my lord.
that
Once
is the only thing that we can do as of now. Because otherwise, to be very frank with you, we do not find any infirmity with the single benches order. So, because you are offering,
yes, my lord.
if you are saying that you have
Yes, my
taken
lord.
instructions,
Their intention is such, my lord. I have been told.
that we are yet to decide whether that is the intention or not. That is why I am giving you, we will be giving you time till the adjourned date of hearing,
Till my lord.
till reopening.
Till reopening. Yes, my lord. Within that period, it will be done, my lord. The Apex Medical Board has also informally been informed that whether it can be done or not, my lord. After their approval, it has been given to me. This instruction has been given to me. My lord, only thing, let it not be considered as a precedence. Let it be a special case because other matters.
We do not have your positive instructions. You have to consider everything, give us your positive instructions. Only if he gets an employment offer, then only we can see whether it's a precedence or not.
My
It's
lord,
too early to say that this is a precedence.
My lord, only thing is the medical examination has to be done under some direction.
Yes, that we will give.
Yes, my lord. Let there be the medical examination done. The subsequent action
will
is
be
such.
done under the directions of the court.
My lord.
That will be done under the directions of the court,
My
but this
lord.
is too premature to decide whether or not it will create a precedent or not.
Yes, my lord.
Nah, should have. By an order dated March 23, 2022. The learned single bench directed monthly monetary cash compensation within bracket MMCC bracket closed to be paid to the petitioner from September 18, 2002, along with interest at the rate of 4% per annum on reducing balance. Full stop. The prayer for compassionate appointment of the petitioner's son was rejected. Full stop. due to the long delay in consideration of the prayer for compassionate appointment, the same was not considered by the learned single judge. Full stop. Next. Mrs. Banerjee, learned counsel, appears on behalf of the appellants and submits that pursuant to the directions passed by this court, a medical examination by the Apex Medical Board, of Eastern Coalfields Limited, within bracket, in short, ECL, bracket closed, may be petitioner's son. Full stop. Next. Considering the submissions of the parties, this court is of the view that in the event an Apex Medical Board is convened and the examination of the petitioner's son is done by June 2, 2023, and an offer of appointment is given by the respondent stroke ECL by the adjourned date of hearing, then the prayer of the petitioner for appointment of her son on compassionate grounds, instead of payment of areas of MMCC, instead of payment of MMCC from the date of death of her husband, may be considered. Full stop. Let the matter appear for further consideration on.
My lord, may I, one indulgence, my lord, appointment from the present date, my lord.
Yeah,
It-
offer,
my-
you bring your offer of appointment, whatever
Yes.
is your, we are not going to state that in the order. You please give your offer, you bring your offer.
My lord,
How can,
within that period, it will be done, my lord. Within the adjourned returnable date, it will be done, my lord. And
8 June, June 8, 2023, under the same heading. Ki heading hai aaj?
and my lord, I'm led by Mr. Vishwaru Bhattacharya, ma'am.
ওইটা bold এ করে দেবেন, Pathak matters, same heading, serve a copy.
My lord, I'm deeply obliged, ma'am.
At 2 PM.
পরেরটাও একই ঠিক আছে না পরেরটা
This is my appeal, Lordship. This is reply. Number of time, Lordship, granted time. Reply and close. This is MCC matter. I filed the notes of argument, already filed notes notes of argument in the instant matter. I file only the additional some notes of point, that's all. This is the reply, Lordship, in opposition. It's also a MMCC matter, Lordship. I filed notes of argument on earlier date. On 2022. In the order sheet recorded that I filed supplementary and the
Yes. What is wrong with the order?
Lordship delay, Lordship, after 20 or 25 years filed, at present, Lordship, interim order, we paid 23 lakhs already. They are claiming from the date of death. I filed notes of argument on the ground of delay and latches and several notes of argument I filed, Lordship, on 20th December. This was recorded in the order sheet of the 20th December, Lordship. I filed now for some additional point, that's all. Because after 20th December, number of things I developed, that's all. On 20th December, recorded that I filed the notes of argument and some judgment on the ground of delay. And after 25 years come before the High Court for the MMCC, we paid as per the 23 lakhs. He's claiming from the date of death. This is the problem.
So what have you paid so far?
23 lakh.
To which period?
From the date of application till today.
When was the date of application? 2020.
No, not 20. What happened? He appeared for the number of times declared fit for the duty, but he did not join, and then not reported. Lots of short notes of argument. I said 2005 she applied, expired in 2005, and applied for the employment. We done medical examination and declared fit for the duty, but she did not report it further. Then after filed writ petition, first time file writ petition after 15 years. Petitioner after 15 years, one application and 20 Lordship made application. But I paid 23 lakhs as per Lordship's interim order.
But the single bench is recorded right from the date of death.
I will challenge that.
The MMCC has been processed by you.
Lordship, as per Lordship division bench, direction Lordship, I paid 23 lakhs. Lordship list up to Lordship to decide. Additional notes of argument I filed. That's all. This is additional notes of argument.
From the, my lord, main issue, there are another issue is here, my lord. I have mentioned this matter before your lordship. Your lordship is directed, my lord, to bring the, my lord, entire thing with your lordship's notice. Your lordship is directed at an initial stage, directing them, my lord, to pay the MMCC from the date of application. They have paid. By this time, my lord, a letter has been issued to my client as to why the FIR will not be lodged against my client.
That is another issue. Lordship,
My lord, thereafter, they have made complaint to the police authority. Police asked my client, though police has not started any formal FIR after the reply given by my client. Now, my lord, this kind of, my lord, thing, when the matter is pending before your lordships, your lordships directed to pay. Now they are alleging that I have made fraud with the court and obtained the order and got the payment. Kindly see, my lord, one, my lord, later.
with regard to age, here his claim his age is 58 years.
Well, age,
58.
age,
And there,
Mr. Kumar,
Lordship,
let him complete first.
Lordship.
well, age has been
Please-
assessed.
Please sit down.
Lord.
Well, age has been assessed by them. They will pay on the basis of their, my lord, age assessment. I am not disputing. I have only, my lord, made prayer that this amount has to be paid from the date of death. Now, if your lordships kindly see, whatever their grievance, they are to come before the court and to say how they can say I have made fraud with the court and they lodge FIR in Asansol when the matter is pending before your lordship. Kindly see, my lord, they are conducted page 34 in my supplementary affidavit. 23rd day of June 2022. This is the lady, my lord, widow of the deceased employee. They will not pay. Court will intervene. Then after they will pay, and thereafter, my lord, criminal complaint. Twenty-third day of June 2022. Kindly see, my lord. Page, my lord, 34. This is the first explanation letter wrote to my client by the authority. Kindly see. This is for your kind information that as per the order of the Honorable Court, MMCC was paid to you. It has been found that you have submitted one affidavit before the learned judicial magistrate Durgapur as on declaring age such and such, which was contrary to the age declared by you before the Honorable High Court at Calcutta. Kindly see one thing, my lord. In affidavit, I have, my lord, said age 50 years. But before the Honorable Court, I have made age 58 years. So I am, my lord, saying more, my lord, thing which is detrimental to my client. I have enhanced my age. Whatever showing in my identity card, in my lord, voter identity card, I have said 58. Now, my lord, kindly see an age declaration by late such and such. This type of mischievous activity is only intended to mislead the court and make fraud with the public money. You are requested to give clarification why FIR should not be lodged against you. So, detailed representation against this order I have made to them. Thereafter, my lord, they lodged the police complaint. Thereafter, I also, my lord, entire thing I have stated to the police authority, though police has not, my lord, understand the reality and they have not started any case. So this kind of practice, my lord, should be stopped.
Where is the police complaint?
Police complaint, my lord, I have no copy because they have not supplied, because they have not started any effort.
Where is the representation?
My lord, page 35, kindly see. This is the representation to the ECL authority first in terms of this order which I have shown to your lordships. Thereafter, representation at page, my lord, 39. Entire thing I have stated.
One.
The merit, my lord, I unnecessary because your lordship's already settled the issue, my lord.
Lordship, page 108 may be seen. 108
Of
of my appeal. What he has stated. 108 of appeal.
can 1,
Lordship?
can number 1.
Yes. Can 1. 108, Lordship, page 108.
There is no 108.
Look. And this is thick one. Page 108, Lordship.
Now you want to be on the basis of a police complaint, other.
No, I am not police complaint, not arguing. Lordship, page 108 may be
No,
seen,
the,
Lordship.
the effect will be other similarly circumstanced, bona fide, illiterate claimants.
No, Lordship, page
they will be
108 may be seen,
dissuaded
Lordship.
from.
108 may be seen, Lordship. What is she stated? What is her affidavit before judicial magistrate? 108 may be seen. Aged about 50 years. In the High Court, he said my age is 58 years.
So had it been the reverse?
I do not know. Very good, Lordship. This is Lordship. This
Because
is
they have,
no,
after that they have.
argument assess. After Lordship order, we assess. That's all. I have nothing to say, Lordship. The High Court, in the judicial magistrate, they made false affidavit. That's all, Lordship.
Yes.
Great.
We are reserving it for you.
Yes, great.
Ashun. Parties slash are represented in the order of their names as printed above in the course title. Also, both Mr. Kumar, Kamalan and Senior Counsel appearing for on behalf of the Eastern Coalfields Limited within bracket ECL and Mr. Ghosh Kamalan and Senior Counsel.
Not senior counsel, Lordship.
According to us, yes.
No, no.
Oh,
That's central panel senior counsel, but not senior counsel.
after you complete that many years, yes.
The central
Formal designation is something different. We give you the value of your years, maybe not of performance. Appears for the respondents.
I'm leading
Respondent slash petitioner and complete their submissions. Full stop para. Hearing stands thus concluded, reserved for judgment.
May I supply my lord notes or my lord, is it required my lord notes of argument or my lord the judgment, because already I have handed over in another matter. But still my lord, I have no difficulty. If you also desire, I can my lord.
If you want, then please bring it by next Thursday. Thursday, 2 p.m. we are assembling. Please bring it by that time.
Very good. And my lord, regarding the my lord, complaint in police, my lord, some my lord observation or my lord something, my lord, kindly think over the issue, my lord. Yes, my lord.
Resolution. Now, this was taken up with Lordship, and there was a direction to file a compilation, which I've already handed over.
All the matters are analogous.
All the matters are analogous.
So give us one matter where you would like to look us.
Yes, Lordship, kindly take up my compilation. That will for you. ওই উপরে আছে
Get a compilation.
কোন পেজ?
এই তো টোটাল টাইম।
হ্যাঁ, কোন পেজ রেফার করছেন?
57 Lordship found the compilation?
We are looking for it.
এই তো এটাই তো বোধহয় এইটাই তো compilation। হ্যাঁ এটাই তো দেখো একবার দেখে নিয়ে নাও।
হ্যাঁ ওখান থেকে
হ্যাঁ এটা না, এটা তো এফিডেভিট কম্পাইল। হ্যাঁ ওই যে ওইটা বোধহয় আরেকটা। Ladyship Justice Banning. Ladyship has found the compilation.
Hope so.
অনেকগুলো দিয়েছে।
Synopsis.
You could have given a heading compilation, a backsheet compilation. You have given a word synopsis.
Synopsis.
So we take this is your compilation.
This is my compilation. Lordship made it.
Yes.
In fact, if your Lordship kindly get along with the Lordship's last order, Lordship will find what were the details hearing. I'm just placing over the issue. Now, if your Lordship kindly come to page 57 for once. What is the situation?
আমি তো মাঝখানে নিউট্রাল, যা বলবে তাই করবো।
What is the issue in all these appeals? What is the issue?
The issue is with regard to, now, if your Lordship kindly, this is the actually the parent order in this matter, which was passed by my Lord Justice Stanton, wherein there was a selection of assistant primary school teachers in the district of Midnapur, wherein serious illegalities have been found, which compelled the court to cancel the whole panel itself.
I submit one thing, will let them, my representative complete. Mr. Bhattacharya is not here. So kindly take up to next thing.
Let my learned friend complete. I am here, my lord.
Gradually, we will not be here. One of us will not be here. That is the whole problem. Mr. Bhattacharya is Bikash Ranjan Bhattacharya.
Yes, yes.
Yes, he was not here in the morning because he had other engagements and another matter. Yes. Now this matter also. Gradually, there is no point in him being here because one of us will not be here.
Right.
Now you tell us what is to be done. How many dates? We have no more dates really before.
Well, next week he'll be here.
No, we have no complaints. Everybody has to attend to his or her business. But one of us cannot be here beyond a certain. Therefore, you have to give us time to. Yes.
In fact, what I'm praying at.
No, you please continue in your role.
Yes,
What is the
yes.
matter about?
Yes. Now, Lord, you will find this was the. Take it, speed. Now, Lord, you will find that from page 57, it starts the mother order, which was passed in this matter actually, by Lord Justice Standen, wherein it has been found since there are irregularities, there's glaring examples of irregularities, His Lordship was kind enough to cancel the whole panel itself. Now, what is important at this present juncture, if you call Lordship kindly takes up page 84 for once. Lordship will find the first paragraph itself. It is shocking that a person who was sponsored under the general category when included in the panel of the scheduled caste category. There is no hesitation in my mind that the selection was undertaken by adopting the pick and choose policy, and some of the persons have been favored where the deserving and rightful candidates have been deprived. Now, this was once again, if your Lordship kindly have a look. This was put on test before the division bench on page 86. Page 86. If your Lordship kindly have a look at page 105 for once. This was there's a continuation of the order of the division. 105. Second paragraph. May I read for the Lordship? However, considering the order of the Commissioner of the School Education dated 6th of June 2012, we find 56 candidates who were sponsored by the concerned employment exchange as unreserved category sponsored candidate were given appointment to the post earmarked for the scheduled caste category. Since no testimonials of the sponsored candidates were made available to the inquiring authority, definite conclusion could not be arrived at with regard to the legality of their appointment by the said authority. However, this problem may be solved if their appointments are confirmed after verification of the records and subject to satisfaction of the caste which they really belong to. Now, this is the observation of the division bench. And if your Lordship kindly takes up if very next page, since no action was taken, once again the writ petitioners initiated another proceeding, which is page 110. Which 110, it once again repeats and reiterates the statements so passed by my Lord Justice Standen that it is stated that it's a shocking once again, and which reveals the second page, paragraph, page 111, which states and reiterates the statements made by the appeal bench once again. And what is being stated at page 112? This is the order by the single bench once again.
Who are you?
I am the person concerned who are before this court today with a leave to appeal, who filed all these matters, got all these orders. We are legitimate scheduled caste candidates who ought to have figured in this panel in way back in 1996. But instead of us, general category candidates have been given appointments. And this is not my own statements. It is the statement of the court, duly affirmed by them, who are the person concerned, from whom my lord, my senior Mr. Bhattacharya is required to appear. And they are the persons who have already been selected way back in 1996. They are having our share of food. It is their own affidavit. I am coming to their affidavits, stating they are general category candidate. They ought to have been in the zone of general category candidate. If due to the fault of the council, they have been employed in the scheduled caste. May I take their own affidavit?
So what is the position now?
If your lordship kindly takes up page 114, this will make the situation more clear.
Yes.
After the order of the court, they have found these persons ought not to have been in the panel. They chose to delist the person from the employment itself. Page 114, it reveals such.
Page 116, concluding paragraph.
Page 114 is the order of the authority itself. If you lordship kindly have a look.
Conclusion is at 117.
117. 117 is the report of the authority, and it's yes. 117 is the order of the. Yes, it is prior to that page 114. If your lordship kindly have a look. This states that these persons ought not to have been. Lordship, have a look. And thereafter 117.
How many of you are there?
We are over here. We have already indicated. Lordship will find from my compilation itself. Yes. (16). 16. Lordship will find from page 14.
Well, how many posts can be kept vacant in the scheduled caste category?
There 56 are there.
All 56 from general category.
All 56 from the general category.
Now what happened? What did the single bench tell you?
Single bench has not inducted me even as a party to the proceeding. They challenged this without inducting us as a party to the proceeding and got quashed that particular memo and got reappointed once again.
Where is that order? Where is that order of the single bench? Which part of the compilation?
Single bench order.
Yes.
Single bench order then. Yes, page 136. Page 136. Lordship will find this is the order.
Against this, you are in appeal.
I am in appeal through a leave to appeal since I have not been made a party and other things. কত মান? 1% of that.
What happened in the Supreme Court?
Yes, Mala.
The single bench refers at page 145 to certain events happening in the Supreme Court. What has happened in the Supreme Court? Kindly come to page 146.
146.
Second paragraph.
146.
Yes.
during foregoing discussions.
Yes.
Yes. Now it would be relevant to set out some portion from the operative report by the Commissioner of School Education. This is the report which reveals that 56 persons are ineligible to be appointed since they are all general caste candidates who have figured as general caste candidate but appointed as a scheduled caste candidate by the blessings of the authority.
Then kindly come to page 147. The report goes against the findings as far as the report. Therefore, second paragraph.
Therefore, yes.
Last resort which was in the hand of the unsuccessful writ petitioners.
Yes. Who are barking
against those 56
men who are rendering services since last 16 years. Persons
was put to an end by this commissioner's
disposal by the division bench. What was the result? What was the finding of the division bench? That these are persons ought to have been tested, and kindly see their own statement. Your Lordship kindly reads with me page 146, the portion of the commissioner's report. No testimonials of the sponsored candidate were made available by the inquiry team, wherefrom it can be ascertained that the aforesaid persons submitted scheduled caste certificates in favor of their belonging to scheduled caste category at the time of the interview. And in fact, today itself, if your Lordship kindly perusal at their own affidavit will reveal they do not belong to scheduled caste.
Please, Mr. Banerjee, come to page 147 again.
Yes.
The last paragraph. Please read the last paragraph. We are unable to make any sense out of it.
It is unfortunate.
Yes, continue.
That the chairman of the Paschim Mendipur, instead of following the observation of the court, which has already attained finality up to Supreme Court, negating the plea of the unsuccessful writ petitioners and wrongly interpreting the, I am also unable to understand, to be honest. What was the direction of the appeal court? If your Lordship kindly takes the pain to take up the order which was passed by the appeal court. Kindly be with me on page.
And that had attained finality up to the Supreme Court.
Yes.
Let us see what is the order
Of the appeal.
Please complete the paragraph.
Yes.
Had broken down simply threat of contempt without going to the ground reality, what the court actually directed, or to state more explicitly what the actual desired from the authority. There can be no quarrel or dispute, could have accommodated any candidate beyond those 56. We do not understand on what logic these 56 are being preserved by the honorable single bench. What is the logic of preservation contrary to you, whatever you are pleading?
I'm coming. What is falling from Lordship's mind? Authority is 56 finding
logic.
You have a look at the finding given by the commissioner at page 115.
We are proceeding that you on the basis you are correct.
Yes.
If you are correct, these 56 are incorrect.
Incorrect.
You are the legitimate scheduled caste candidate and these are not scheduled caste candidates.
This is not only my statement. This is our own affidavit.
Oh, you are correct.
You are correct.
Now, if you are correct, then that has been affirmed up to the division bench. He said that please test that caste certificates and see. That has been tested. That may have been affirmed out of the up to the Supreme Court. Now, from this logic of the order impugned before this court, we are at a loss to understand now how are these 56 which you say are incorrect and you are correct. How the division bench could protect these seats? Tell us the logic behind the order.
Now, if your Lordship kindly be with me, what was the challenge before the single bench? What was the challenge?
Could you not tell it in your own words what happened? Just in your
challenge was, now, if I do skip over the papers, challenge was the authorities found that these persons are unsuitable to be in employment since they are not scheduled caste candidates. And that is the reason why their employment was quashed. That was challenged without inducting ourselves in the party, in the proceeding, and straight away cancelled that quashing. And now they have been re-inducted in the employment. This is our prayer. Now, if your lordship kindly be with me for 1 minute, their own affidavit reveals that their names have been sponsored as the general category candidate. And they ought to have been employed as the general candidate. I don't mind whether they will be fitting themselves as the general candidate or not. Vacate my place and let us be appointed. I don't want to go for a quashing of their appointment. No. If they can fit in with the general category, I don't mind. ষোলো জন না ওই আরেকটা আছে মেনকা মুন্ডা আছে দিয়ে দিচ্ছি সেটাও দিয়ে দিচ্ছি দাঁড়া এবার প্রতীকের অর্ডারটা একটু এটা নয় এটা এখন
Today, you will not get a date like this when you can argue to your heart's content and complete whatever you have to. You may not be in a position to get a date like this in the coming 1 month or so. So please continue and finish.
Yes, if, since your lordship is going through it, I'm just holding myself.
There's nobody between you and the court and 4:30.
And no 3:30.
That's right. So please do something about, utilize your time.
Grateful. Now, if your lordship kindly be with me for once again with their affidavit, which I've already enclosed herein. Yes, page 154. This will make the situation more lucid. This is their own stand in their affidavit. Paragraph 10, I am skipping 6-7 lines from the top. It is further, if your lordship has found it. May I read for the lordship? With regard to the statements made in paragraph number such and such, of the said application, deny and dispute the same and accept what shall appear from the record expressly admitted by me. I state that the chairman, the respondent number 5, passed the impugn order communicated under his memo dated such and such, whereby and whereunder the appointment of the writ petitioner was cancelled illegally on the plea that the appointment of the petitioner as primary teacher was made under SC category, though he was sponsored under general category. It is further stated that the authority concerned illegally cancelled the appointment without considering the fact that the writ petitioner participated as general caste candidate. And the employer during the employment never informed the writ petitioner that he was placed in the panel of scheduled caste category. However, at the fag end of the service period, the respondent number cancelled the appointment.
Accepted.
Lordship was found.
Now, how did the single bench, why did the single bench say, no, that action was correct? What is the logic of the single bench? Tell us on what, you are correct. You are accepted. This position of fact is accepted from you. Now tell us the logic on which the single bench still protected that action of appointing them. What was that?
In
logic?
fact, to be honest, be very honest from my side, without going through the order, I couldn't understand. Because without inducting us a party, on the very day it was disposed of.
It could, maybe it could have been done. What is the logic still?
Now kindly have a look. What was the statement?
On what particular piece of evidence, what particular point did the single bench not agree?
I'm following, Lordship. 147. Now, this 147 is the actual guideline on the basis of which their appointments were protected.
So that is what we were there. We were on 147.
147.
Before you were there.
That, if Lordship kindly reads 146,
I think please read from 147 onwards, because we also have to comprehend on the basis of which the single bench has
came to this conclusion. I follow what is the ladyship's on. Prior to that, Lordship kindly hit 146 for once.
All right.
Since this was quoted, no testimonials of the sponsored candidates were made available to the inquiry team, wherefrom it can be ascertained that the aforesaid persons submitted SC certificates in favor of their belonging to scheduled caste category at the time of the interview. No records relating to issuance of appointment letters to the impaneled candidates were also made available. So the team also unable to ascertain the exact category which they belong. In 2002, the erstwhile Midnapur district has been divided into Purva Mendipur and Paschim Mendipur. Many of the aforesaid persons may now be posted under the jurisdiction of Purva Mendipur District Primary School Council. The Paschim Mendipur District Primary School Council, being the appointing authority as well as the custodian of the previous record, is instructed to ascertain the category of the aforesaid 56 persons as well as the other such candidates whose sponsored list cannot be verified, like Komalindu Maiti has stated above, by the inquiry team due to the non-availability of relevant records at the time of the visit, and initiate suitable action if found otherwise after verification. The list of the persons, those who were posted under the present jurisdiction of Purva Mendipur District Primary School Council, be sent by Paschim Mendipur District Primary School Council in the Purva Mendipur District Primary School Council for taking up the matter with them similarly. Thus, the allegations as raised by the appellants have been addressed fully, except the case of 56 scheduled caste candidates as mentioned above, and the issue as indicated in para 1.5, where number of trained candidates, I'm skipping over. Therefore, Lordship was found with regard to 56 candidates, there has been a say that these persons has never been in the scheduled caste category. And what is the finding of the learned trial bench? Therefore, at the last resort also, which was in the hand of the unsuccessful writ petitioner, who were barking against those 56 panel primary teachers who have been rendering services since last 16 years, as on the date of the disposal of the appeal were put to end. I'm unable to understand. If your Lordship kindly be with me for 1 minute, Lordship will find the cancellation here to the cancellation memo. Page 114.
You have been called to further read. Her ladyship requested you to instructed you to further read page 147.
I'm coming. This is 147, against which practically this 114 was given a go by. 114 is the cancellation memorandum of these 12 candidates who is being out of employment since they were unable to produce their records. Thereafter, I'm coming. Just be with me for 1 minute on page 114. Thereafter, I will come into 147 once again. I cancel the appointments. Kindly have a look. Pursuant to the order of the court.
Yes, you appear for the writ petition or appellants, all the appellants.
Appellants.
All the appellants.
Here, all the
Please
appellants.
let us refresh our mind.
Yes.
Please give us an opportunity to consult some other lawyers who are.
Great.
Mr. Chatterjee, whom do you appear for?
Primary School Council, Paschim Midnapur Primary School Council.
What is the position? Can you tell us from the discussion?
Now, my lord, the
Mr.
position.
Banerjee, you may take your seat. We'll come back to you.
Good.
What is the
My lord,
position?
after the order of the division bench, the honorable division bench passed the order directing us to consider the testimonials of 56 candidates who has been appointed under the post of the scheduled caste candidates. Now, my lord, this consideration was made. Records are not available. Ultimately, the commissioner passed the order for cancellation of their appointment. Accordingly, 12 persons' appointment has been cancelled. 114 of the compilation. That was under challenge before this honorable court. And before this honorable court, the challenge was successful as raised by the writ petitioners. The honorable single judge, while deciding the issue, come to the conclusion that the cancellation made by us is unauthorized and uncalled for. So this is set aside. Now they have come up for the appeal. We are in the mid position. Well, the division bench has directed us to do these things. We have done. We have come to the conclusion, yes, 12 persons, we found it, that rest, because now this is the appointment of 96. Most of the persons have retired or died. After retirement, died. They are no more in the service. Rest, the persons who are there, they have been identified. Their testimonials have been checked. They did not produce anything as regards their claim in the scheduled caste. So, their services have been terminated. 12 persons' services have been terminated. Accordingly, the termination has been done in terms of the order of this honorable court.
The division bench.
Division bench. As affirmed, honorable single judge, affirmed by the honorable division bench, affirmed by the honorable Supreme Court.
Yes.
Then, my lord, the cancellation, page 114 is under challenge.
At page 147.
Yes, 114 is the order of cancellation. Your lordship, can you see the order of cancellation? This is the order of cancellation. Is passed by the chairman, Paschim Midnapur District Primary School Council.
114.
114.
As all the records of the teachers are not.
With reference to the above and pursuant to the direction of the Honorable Justice Aniruddha Bose dated 15/4/2016, it is informed to you that I cancel the appointment of 12 teachers on 27/7/2016, named this. These are all the writ petitioners in that writ petition filed before the Honorable Single Judge, which the order has been under challenge before your lordship. These are the 12 writ petitioners.
ইনভেস্টিগেশনটা তো পুরোটা হয়নি
Now, my lord, this is
about the last 3 lines.
Yes. Again,
that
I
order of-
requested the chairman Purva Midnapur. This is Purva Midnapur.
Last 3 lines. As last 4 lines.
As all the records of the teachers are not find out or reached to to me. So it is difficult task to trace out the rest teachers. However, I requested again sub-inspector of the schools of my district, provide memo number such and such, to trace out the records immediately. Immediately as for taking decision from our end.
Then what happened? Because the exercise is not complete.
Now, this order, this order is under challenge. Who said this? No. This is not the subject matter. তারপরে কি হয়েছে রঞ্জন? তারপরে কি হয়েছে?
ঠিকই তো আছে, এই তো গঙ্গারানী সেন তো দেখিয়েছে, এইটুকু এটাই তো চ্যালেঞ্জ, এটাই তো
এটাই সাবজেক্ট। মানে the order we have passed মনোরঞ্জন দাস,
So now what is the position? 56, we start again from where we had to start. 56 appointments in the general category given, which were supposed to belong to scheduled caste.
in the undivided Midnapur.
Undivided Midnapur, 1996. Now, those 56 appointments challenged by persons who participated and who were scheduled caste candidates. Single bench set aside the panel of 56.
Or entire panel.
Entire panel.
Entire panel. Division bench restored back the entire panel only in respect of 56 candidate, directing us to
do an exercise.
To do this exercise.
Out of the, when you did that exercise, you found the 12 records.
No, 12 come to our district in Paschim Midnapur.
Right.
Some are in the Purva Midnapur.
Right.
That we did not find. We have asked in this order Purva Midnapur to find out who are the persons.
So therefore 56 less 12 is
44.
Right.
There are some candidates also in the Paschim Midnapur, but their records are not available and they are all also not alive for surviving candidate in the matter also.
Now then what happened with the rest of the leadership?
Now the thing goes further. These particular persons filed another writ petition asking that these persons have been retired, give us appointment in their post.
Could not follow that line.
The persons who prefer leave to appeal, challenging this order,
Mr. Banerjee's line.
Mr. Banerjee's client, they filed another writ petition before this honorable court. This is the writ petition number. Bhagodar Duli moved 18250 of 2021. Their prayer is to give us appointment in the post where this person, from where this person scheduled caste, scheduled caste post, where from the jail candidates have been retired.
Who is the advocate on record?
Mr. D.K. Odhikari and Mr. Banerjee is the counsel.
So now they seek appointment in respect of these.
That post earmarked for scheduled caste who have been retired. Now, these candidates who are in the fray.
Any adjudication on that?
Yes, the matter has been admitted and the direction for affidavit has been made.
And then, but those gentlemen, those 12 who have been sorted out by the Paschim Midnapur District Primary School Council.
They moved this writ petition.
They moved the
writ petition. The honorable single bench set aside the order.
And therefore reinstated. And hence these leave to appeal.
Yes.
And in the meantime, that writ petition after this leave to appeal. So before this leave to appeal.
No, after that 21.
These leave to appeals of the year?
This lead, before that, no. This order passed by the Honorable Single Judge
Yes.
in 2016. The writ petition moved in 21. The appeal filed in 22.
But for them, they are chasing a situation where they have to be, they are seeking appointments against the same scheduled caste.
Same scheduled caste candidates. Number
Since records are not available, persons have died. So therefore, strictly, how can they be faulted for seeking an appointment against those who have now retired?
Number they have the age. They don't have the age for getting appointment.
I've already.
We are not asking you to interrupt now.
Sorry.
Yes.
They don't have the age. The age qualification is also one qualification. Now, the procedural appointment has been changed.
Which means all of you are going, the original sin has not been purged.
Yes. No. Now, if they want to seek the appointment, they could have sought the appointment in 1996 election, where the original order was passed, not any subsequent, because they participated in 1996 election. Thereafter, they did not participate.
1996 order. How do you stand order?
এই অর্ডারটা চ্যালেঞ্জ করে রিট পিটিশন হয় না
এই যে পেজ 57 ঠিক আছে
21st July 2016 এই তো এইটা থার্ড
2012.
Yes, the appeal filed in 2012 in leave to appeal.
In a writ petition, as the leadership points out, of 96.
96.
Then they have done something in 96.
No. 96 original writ petition. Final Justice Tandon was pleased to pass the order, setting aside the entire panel, challenging that appeal preferred. The Honorable Appeal Court, presided by Final Justice Jyotirmoy Bhattacharya, was pleased to restore,
That story is known.
restore back the panel only in respect of 56 candidates. Then matter went up to the Supreme Court, that 56 candidates. Supreme Court affirmed the order of our High Court. Then these proceedings have been taken by the Commission of School Education. Identified these persons, their employment has been terminated. Challenging that order, this writ petition filed, several other writ petitions, litigations have been filed, contempt applications have been filed. So many litigations have been filed. If I give you, Lordship, the list, your Lordship will amass. How many proceedings have been initiated by these persons?
So no, according to you, no meaningful order can be passed now.
At the present moment, that 96 consideration has no effect at all. Secondly, the procedure for appointment at the present moment, as on today, is something totally changed. Seesaw changed. Qualification is also changed. These persons are madhyamik, I believe. এই 2018 সালের রিপিটিশনটা করতে গিয়ে এই যে বলছে 2018 এই অনিরুদ্ধ বসেরটা অনিরুদ্ধ অরিজিৎ ব্যানার্জি 119
Mr. Banerjee, let us think of a situation where this is happening, where from 96 you are trying and people have got jobs.
Illegally.
Of course.
It has to be.
I think when you are supposed to get the job.
Yes.
And not 1, 2, not 4, but an entire panel of 56.
Yes.
So now the question is, maybe people have died, people have retired, you may be age barred, etc. We want you to do an arithmetical calculation. We are sharing it aloud. Suppose you would have got the appointment in 96 and till your date of retirement, what is the amount of money you could have earned?
Great.
We'll ask the 2 district primary school councils to pay you. Because we are not being able to give you any, you have retired, etc.
If
You
you
make a calculation. No, please listen to us first. You make a calculation.
from 1996 onwards,
Individual kinds of 12 petitions. If you would have got the appointment
on that material day.
for all 16 or whichever you represent, that this is the way, this was the scale, this was the money we would have got. And up to the date of retirement, including your pensionary benefits. You give us the amount, we shall now hold the 2 district primary school councils responsible.
If your lordship kindly take up my compilation.
Otherwise, we are not here to just hear the matter.
Number to that extent, my submission is this, that the persons who have not been given employment and in their place, the general candidates have been appointed. The general candidates have been appointed, they have been got the salary, they do this their job and they have retired. They challenge the same and by the prosecution, this is the time this has been spent. Well, may I put this question to us? Where is our fault? Where is our fault?
Nothing. Your fault was to give
in 96.
Yes, 96, your fault was to give the 56 posts to general candidates. Whoever was at the helm of affairs. And you pay for your faults. Who else pays for it? Because whoever was there, we are not saying whoever might be there, it is the fault of the primary school council who appointed them.
No. Not these. These are the 12 rest. But who are these 12%? We do not know. We do not know whether they are actually got the requisite marks for getting appointment or not. That also we do not know. We have only calculated, as per the court's order, we have indicated that this person's service have been gone. We have not made any order for giving them appointment because we do not know till now whether they are eligible or not.
Answer this.
I'm coming. For a moment, if your lordship kindly turns up what the very page which my senior was repeating, to trace out the state teachers immediately, trace out the rest of the teachers.
Answer the last query.
Coming.
How are you within the threshold of being appointed?
Yes.
Why
I've already been given appointment to the other matter. For a moment, Roshi, kindly take up what page 115.
show that first.
Yes.
By the time you're coming, we have gone.
No. For 1 minute, why I was hopping on the page 114, it was stated by their own stand that we are tracing out the other teachers. Now let us see page 115. It once again reveals another 12 has been detected. These ought to have been thrown out. Page 117. Page 117, it reveals these are the additional 12 which ought to have been thrown out from the employment. And this is the order.
No, very well. But where from?
Kindly, Mr. Chatterjee.
Where from their selection have been approved?
I'm coming. Why are you so impatient? Page 112. Pursuant to this memorandum issued by the government that these petitioners would be thrown out from the employment and the panel is being directed to recast. My Lord Justice Banerjee, as his lordship then was on page 122. Let's see what is the order. Page 123. There was also the same issue. Since it was not challenged, I came before the court. I got the order, which was complied. Page 125 onwards. How can he say all these things now? Separate selection process and other things. Kindly see the date. This is page 2021. I have been appointed. Page 125 onwards. Of the same panel, these are the persons. 12 deducted, 12 fresh people who ought to have been over there from 1996 have been inducted and given appointments.
We are only asking you, now we are asking you what Mr. Chatterjee said. Very well. Now you can be appointed.
Yes.
Show us that how can you be appointed? In the merit list, you had crossed the merit position. You were part of the, where is the evidence that you, in that selection, you were fit to be appointed?
Let them recast the panel. First let them throw out this 56 who ought to have been in the general category. This is the order of the single bench, for which I've already a few.
Now, hypothetically, if you throw out these 56, did you have a copy of the merit list with you?
As if your lordship kindly be with me. Excellent. Finally come to page 50.
How many scheduled caste appointments?
Yes, I'm coming. Page 48, lordship kindly come. This is their own inquiry team. Page 48. This is the inquiry team of the government. Pursuant to the direction of the court, this inquiry took place, which reveals the list from page 53. Kindly see the category with rank, scheduled caste. Everybody has been stated to be a scheduled caste candidate by the council in order to furnish them appointment.
Can you just tell me quickly the serial numbers of the writ petitioners? In that
Writ petitioners are not figuring. These are all false. These, kindly have a look. Paragraph 8, lordship, kindly have a look.
Please try to understand what his lordship was asking you. Please try to show the eligibility of the writ petitioners where you appear in the list.
I cannot come within the zone of consideration. The general category candidates have been given the appointment. Until and unless they have been obliterated from the list, how can I come within the situation?
As far as the scheduled caste candidates are concerned, where is your ranking? Please show.
I cannot come within the rank. Kindly see my difficulty. If general candidates are filling up the post, how can I come within the zone of consideration? How can I? That is the reason why there was this
panel was prepared.
Prepared.
No scheduled caste.
No scheduled caste. This is the situation.
No, scheduled caste was there. Who said it?
Kindly have a look at the page 53, the right-hand column. Kindly be with me for 1 minute. It has been stated all scheduled castes. And let us see page 55, the last parameters, what has been stated. No testimonials. How can we say? This is their own scheme.
Of the aforesaid persons.
This is all false.
No, your lordship, can you see what is the sentence? No testimonials of sponsored candidates made available to us, wherefrom we can ascertain that the aforesaid persons submitted SC certificate. These aforesaid persons means Narayan Chandra Gorai is also a scheduled caste candidate.
He is not a scheduled caste. He has been inducted as a scheduled caste. He is not possessing the certificate. Maybe he is not being properly briefed by his junior. Kindly read the whole sentence. That is the reason why these 12 and subsequent 12 has been thrown out of the employment. Since they have failed to produce, I don't mind whether if they retain in their service.
No, they have been thrown out. Now, where do you come in? What is your position?
Now.
They have been thrown out. Yes.
First, they have to be thrown out. Once there is a vacancy of 56, the panel is to be rescheduled. Once it is being rescheduled, lordship has seen 12 has already been given appointment by recasting. I will also come within the zone. First, let them be thrown out. They are holding the place. They are having a place, having a share of food gulp from 1996, which your lordship just indicated minutes back. How can they say all these statements, scheduled caste 459, these are all false?
Understood.
Now, if your lordship,
What in the original advertisement, how many scheduled caste posts were?
Kindly allow me to make my submission. I will clear entire picture.
Everybody is saying he'll clear the entire picture,
because
including us. We are also trying to clear the entire
1986
picture.
panel has been started.
And we are all trying to coming to the entire.
Kindly allow me to say, for 1986, the panel has been started. At that relevant point of time,
1996.
86. And name has been called for from the implementation. That is the system. There is no such a scope of any advertisement. Now, after the name has been sponsored,
the panel has been, we have not, there is, at that relevant point, there is no scope for filing any application by the candidate. Only name sponsored, the authority called for the interview, then the panel has been prepared, panel approved by the Commissioner of School Education, previously Director of School Education approved the panel, the appointment has been made. Well, here in this case, at that 11 point, two panel has been prepared, one for trained, another for untrained. There is a 1940 rules. There are two sets of panel, 50% reserved for trained candidate, 50% for the unreserved candidate. In both categories, scheduled caste, scheduled tribe, in all categories. But in the present case, the petitioner not disclosed whether they are successful in the trained candidate or not. But there is a non-trained panel is there. There is no inclusion in the general caste category panel candidate. Only untrained candidate, there is no availability of this trained scheduled caste candidate. That is why general trained candidate has been inducted. In our case, we have got higher marks than the lowest card marks of the general category. And that is why you have given, I don't know whether they have been put my name, placed my name in the scheduled caste or not. After
So they are, according to you, non-trained.
Non-trained. Perhaps they have not disclosed that fact.
And you are trained.
Yes.
And there were no trained scheduled castes.
Some trained scheduled castes is there, they have given appointment.
So what a very interesting situation in 96. The single bench has found that the entire substitution has taken place. Scheduled castes, how could you appoint?
And panel, you will also kindly give me liberty. I shall produce the panel. Because panel has been supplied by the court. Just copy. I shall produce the approved panel, which was supplied by the Honorable Court.
No,
They have
but
also received the panel. They have not.
But the single bench, your own commissioner, your own district primary school council, the division bench are saying that these 56, you completely supplanted them with general category candidates. And your argument is nowhere noted that because there were no trained SC candidates, trained general category candidates.
Well, only I have stated that I have obtained higher marks than the lowest general category, lowest reserve category candidate, general category candidate. I have obtained high, that is my evidence in opposition also.
But then none of the courts have agreed with you. And on top of that,
that order has been challenged. One of the order has been challenged by the before the Hon'ble Court. That is, your also kindly come to page.
Now we were only on the point.
Well, Lord, kindly come to come.
If Mr. Banerjee satisfies us, then your district primary school council has to pay a lot of money. Right from the day they were would have
One
got
of the candidate Deepak Tinda filed the petition, the named person, page 107. 117. Kindly come to page 117, Miller.
An entire panel substituted.
But Deepak Tinda challenging this order filed the petition. That deed was allowed. This is the second matter.
Yes, 107.
Yes, Mala, one candidate, Deepak Kumar Tinda is there, my lord.
117.
Serial number, page 117, my lord.
107.
Yes.
Well, Deepak Kumar Tinda challenged this order and they obtained the order.
Of the Honorable Single Bench.
Yes. That was no appeal paper.
Now special leave to appeal is preferred.
No, not against this order also.
Where is that order?
Yes, this is the order. Kindly one copy with me. Kindly excuse me, my lord. Just to have একটা কপি দাও আরে আমি একটাই কপি ছিল আমি কোর্ট থেকে নিয়ে দিলাম কি লোকটার নাম কি এটা দিনদা ফার্স্ট নাম যার দিনদা কে দিনদা তো ইয়ে
লেটেস্ট
জালি আর জালি কিনা তুমি তো এটা আমাদের পার্টি কিছু করেনি কেউ I don't know what is handing over because if I don't know because I have not been made a party in the proceeding. Had that been so, this person ought to have been. We have not made party also. Where? Yes. Is whose petition you be made a party? Are your petition scheduled caste? What he is telling?
রিট পিটিশনে তো সুপ্রিম কোর্টে চ্যালেঞ্জ করতে গেছিল, মানে আগের রিট পিটিশনে ওই থেকে ছিল সুপ্রিম কোর্টে চ্যালেঞ্জ করতে। কোয়ালিফাইড কেন? হ্যাঁ সেটাই বলুন, ওরা খুব কোয়ালিফাইড, আমার দরকার নেই। হ্যাঁ আমি তো দেখিয়েছি থাক না, আমার কোনো আপত্তি নেই। আমি জেনারেল চেয়ে বেশি নাম্বার পেয়েছি লাস্ট টাইম, দিয়েছে ওরাই জানে, আমি কি করে যাচ্ছি।
Mr. Chatterjee, there's a question which is now, you had raised that point. They have to say that they were eligible for appointment. The panelist belongs to you.
Yes, yes, panelist with,
So
with
you
us.
must be having some idea what is the panel about, what is
At the present moment, I don't have any idea. At the present moment.
sub judice matter.
But sub judice matter, no doubt, I ought to have been taken instruction on the panel, but it's my wrong decision, I did not. If your lordship, next Thursday, your lordship is again assembling, I shall take instruction on the panel, I shall go through the panel, I shall apprise your lordship on the
Their
panel.
eligibility.
Yes.
Yes, their eligibility, there must be a merit list.
Yes, yes, yes.
On the merit list, there must be category divided.
Yes.
Now, the scheduled caste must be one of those categories. Now,
No
if
doubt.
that is a category, there must be a cutoff mark for.
Yes,
scheduled
yes, yes, yes.
So these 56 posts must be above the cutoff mark. Whichever are scheduled for scheduled.
They are not 56, they are 12 in number at the present moment.
That's right. 12 in number as far as they are before this court.
Yes.
You see, if everything else, we have to go by whatever has been handled in that particular.
Very well.
Now, if these 56 posts are for scheduled caste category, and these 56 posts must be above the cutoff mark then for scheduled castes.
Yes.
Then if these 56 posts, what are their cutoff marks?
That's right.
That's it.
That's right. I shall indicate before lordship, or I shall place before lordship what the marks they have obtained and what is the cutoff marks.
No, not only
Scheduled
that.
caste.
For scheduled caste.
Not only that, for
We're coming to.
yes.
We're coming.
Yes.
For
Not only that.
the scheduled caste. Now the question is this: if this 56 goes, then what will be the cutoff marks goes down? My learned friend is saying this. I am not on that. I say that if this 56 goes, even then they may not come within the zone.
We'll have to look into that because everything. This is we are hesitant to use the word now. It's too early, maybe, but this is a scam which happened in '96. You substituted an entire panel of 56 persons by general candidates.
It may not be a scam if there is a provision in the Primary School Education Act also, as also the Scheduled Caste, Scheduled Tribe Act, that if the Scheduled Caste, Scheduled Tribe post cannot be filled up with qualified candidate up to the cutout marks, it can be filled up by the general candidate having requisite marks.
So far, none of the courts have agreed with that. I mean, even if you had that rule right up to the Supreme Court, none of the courts have upheld this view.
Even that is not their statement in their affidavit.
They have
There's a new statement being put forward to
right now. We have to go by final orders of court.
No doubt.
Follow the orders of court.
That is the law prevailing in our state. That I can show. Now I have to show your lordship that what is the marks they obtained and whether if this 56 gone, whether they will come in the zone or not.
what they are really harping on.
Now, Mr. Banerjee is to supply my learned advocate on record their roll numbers.
Yes.
Their roll numbers, so that I can find out it from my record what is their position, what the marks they have obtained.
We do not have much time at our disposal.
But
So we need this.
let him provide me the roll number by tomorrow. I shall look into that. I shall inform you also next Thursday itself.
No, only one thing. These are practically unnecessary things being argued today. To be honest,
my lord.
kindly. I was keeping mum for some time. If your lordship kindly take up of 117, lordship will find the subsequent 12 people who have been obliterated from the list. There was a direction from the commissioner to recast the panel. And if your lordship kindly be with me for 119, the court's order decides that you throw out these persons and you appoint these persons. All the persons
what are you appoint this person?
Kindly read with me without reading why you are shouting. Kindly read with me with my Lord Justice Pratik Prakash Banerjee's order for 1 minute. Page 123, I'm reading for your lordship for 1 minute. Accordingly, kindly be with me for 1 minute on page 123.
Mr. Banerjee, be temperate in your line. Nobody is shouting really.
Yes,
Everybody
my lord.
is. Be temperate so that the environment is congenial. Yes.
Oblige, my lord. Accordingly, the state has no defense for not having complied the order dated such as such. It is needless to mention this is not a case where contempt of court is a proper remedy before the order of the court has been complied by with the Commissioner of Education when he passed the order dated page 194. Therefore, let the order dated such and such be complied with, and the respondent 3 and 4 whoever shall terminate the appointment of the private respondents and also recast the panel in the terms of the order dated such and such and appoint the private respondents as also recast the panel in terms of the order with consequential benefits. What don't please?
Where is the appointment order?
Now come to the appointment order.
Shall terminate the appointment of private.
This is your appointment letter.
1 minute. What is the written in the order sheet?
Yes, read out.
I'm reading that. Shall terminate the appointment of the private respondent as also cast the panel in
Recast
terms
the
of the
panel.
order at page 194
with consequential.
consequential benefit.
Yes.
With
and now
where is that order that they should be appointed?
Kindly. Page 125 onwards, there are all the appointments of these persons who knocked the doors at that particular point of time. Kindly be with me on page 125 for once. In compliance to the honorable order of the honorable court, such and such, Ashok Kumar Gorai is duly appointed. Page 126. Page 127. Page 128. Everybody
They are not these persons. They are not these persons.
I am telling these are the second batch who have been appointed.
They are not this. Let them supply their roll number.
We will supply.
I want to help
one thing. Yes, he is helping me. And
kindly, also the documents available with them.
Kindly,
so that we can verify, we can give correct picture before this.
One thing which is also to be very much noted out here, since 56 persons who have been inducted as scheduled caste from the general caste, whether they are within the marks or not, whether they actually having the marks, he is raising high.
Even if they are not actually having the marks, they are not belonging to the same caste, they automatically go. Marks or not, we are treating 56 to be vacant.
Grateful.
56 blank.
Let them be thrown out.
Right. Now from you only, scheduled caste only, we are asking them for the cutoff marks.
Yes.
And only we are asking your roll numbers with your cutoff marks so that you are part of anywhere. You're part of 12, 16, 56. The 56 we are keeping blank now. The general category can, because we want to see where you stand as far as forget the recast, forget the position, and even after it.
If your lordship do not order for a recast, the marks will not lower down. 56.
Very well.
Yes, 56, the 56th candidate, 56 scheduled caste candidate.
The last 56 candidate.
Scheduled caste candidate, not scheduled caste. Yes.
What is the cutoff?
What is the cutoff marks of the last 56th scheduled caste candidate? That will govern. And
let them supply us that roll numbers.
And only one thing, lordship is kindly directs us with that from 1996 onwards, what would be our salary. Kindly direct.
Yes. Do that homework, keep that with you till we first get to this point. The roll numbers.
Roll numbers to the
we meet. Ashok.
My lord, I think it's carrying with my compilation itself from page 16 onwards. Why you unnecessarily buying time? Affidavit করে দিতে page 16 onwards it reads. I'm having the roll numbers out here. I'm having the admit cards. Page 16 onwards. From the compilation, Lord, you will find.
Olokesh Mondal, কোথায়?
Leave to appeal has been granted.
My lord,
Leave to appeal has been granted.
has been heard.
Has been granted.
No, Lordship will be granting the leave.
তিনি এখনো
At that particular point of Lordship was, since your Lordship was hearing altogether.
এটা সরাতে ভোট
Admit card.
এইটা নিচে এটা
না না এই দামে নেই তো এই অন্য লোকে
অলোকেশ মন্ডল রিট পিটিশন আছে?
এফিডেভিট না করলে হবে না না নেই এখানে
এই তো অলোকেশ মন্ডল।
না না
এই দেখো অলোকেশ
রিট
মন্ডল।
পিটিশন
এই তো।
আমাদের লিফট অ্যাপিলটা বার করুন না।
হ্যাঁ
পেজ 16 পর থেকে যারা যারা আছে তারাই মিশন চন্দ্র বর্দিকি
লিফট অ্যাপিল
এই তো আছে, সবাই আছে।
ঠিক আছে
Everyone is coming. I've already
আমরা দেখে নেব।
ডকুমেন্টস দেবো না, ঠিক মতো। এইভাবে দিলে হবে না এইভাবে দিলে হবে না।
কোথায় রোল নাম্বার কোথায়? এই রোল নাম্বার কোথায়? এটা তো মেমো নাম্বার।
ওইটাই তো পাবে, ও তো অ্যাডমিট কার্ড তো এটা।
না 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 এটা এটা
অ্যাডমিট কার্ড বসেছে
Mr.
তারপর
Chatterjee,
এই তো
Mr. Chatterjee, they will supply you afresh. Please take your seat. There will be an order of court.
Yes. This is not the roll number. This is memo number.
ওইটাই আছে।
No,
দিলে হবে না।
this is not the roll number.
সিরিয়াল নাম্বার তো উপরেই আছে।
Leave to appeal দিন।
এই তো দুটো বাইরে আর কি আছে? এই তো প্রত্যেকটা পেজেই আছে।
বুঝতে পারছি না ফ্রেশ করে দিতে হবে।
Roll number.
Yeah, leave to appeal granted by which order?
No, leave to appeal
Has not been granted.
Which is your application for grant of leave to appeal in each of the appeal? Can number?
Yes.
ক্যান নাম্বার, এই ক্যান নাম্বারটা
No, no,
এটা চারটা
Just the can number in each of the
ক্যান
appeals
নাম্বারটা
no, no, এখানে এটা কোথায়?
for leave to
ওরা
appeal.
যে লিস্টটা দিয়েছিল, লিস্টটা কোথায়? কম্পাইলেশন
কোনটা
এই তোদের কম্পাইলেশন
ক্যান নাম্বারটা দিল স্যার।
ওটা না ওটা না ওটা ওরা একটা লম্বা করে লিস্ট দিয়েছে বলছে।
আমরা দিন
আমি দেখিনি।
এই তো এই কোনটা এই কোনগুলো আছে তো বলতে হবে, অনেকগুলো ক্যান আছে।
এই যে
কোনটা এগুলো অনেকগুলো আছে তো। আরে এখানেও তো আছে, ওখানে চলে যায়।
Take your seats. Party parties is slash are represented in the order of their names as printed above in the course. First, the appellants are aggrieved. Take two details. The appellants are aggrieved by the order of the Honorable Single Bench. Dated
এটা আপনি ফ্রেশ করে দিয়ে দেন।
the 11th of January 2018
আরে যেটা
in WP number 16313 within bracket W of 2016.
পরিচয় যাও করে
Full stop.
করে যাবো।
Full stop. Mr. Banerjee, you have your discussion later. And what is the application for leave to appeal?
Well, there are several
Ask
numbers.
Lanet Junior to write out in respect
Yes, I'm
of
supplying
the
the number.
appeals, otherwise this order will not be uploaded.
Okay.
Ask him to write against each MAT
Each
number,
and MAT number.
the leave to appeal application number, only the leave to appeal. Can 1, can 2 against each MAT.
প্রত্যেকটা ম্যাটের যেগুলো এগুলো আছে করে ওনাকে দিয়ে দেন।
Please take your seat. কি বললাম? In the writ petition being WP 16313 within bracket W of 2016. Full stop. Para, the appellant submit to Mr. Banerjee, Learned Counsel, that they were not parties, that they were not impleaded as parties to the writ petition. In bracket Supra, bracket close full stop. The appellants further submit that they participated in the selection for appointment as primary school teachers in the scheduled caste within bracket SC category in 1996, conducted by the then undivided district primary school council, conducted by the district primary school council of the then undivided. Yes. And you appear for the of the then undivided district of Mednipur. Full stop. The primary contention raised by the appellants is that in the said selection, 56 posts belonging to the SC category were allowed to be filled up by general category appointees. Full stop. The appellants submit that they have been fighting their legal battle ever since, seeking the setting aside of the 56 numbers of illegal appointments in the SC category by general category candidates. Full stop. The appellants succeeded before the first honorable single bench in WP number 5137 within bracket W of 1996 by declaration of his judgment and order dated 14 December 2012. Full stop. Upon the said order of the honorable single bench being carried in appeal, the first honorable division bench by its judgment and order dated where is the order of Justice Jyotirmoy Bhattacharya page?
Lord is asking.
Justice Jyotirmoy Bhattacharya.
Yes, yes.
Page.
Right. Next, 1-1-10, I hope. Yes.
So the first one by his judgment and order dated
86.
Thank you. 21st of February 2014 in MAT 278 of 2013, along with other appeals, was, inter alia, pleased to direct verification of the records of the candidates and consequential steps upon such verification. Full stop. The matter arrived before the Honorable Apex Court, which affirmed the order of the Honorable First Honorable Division Bench, dated the 21st of February 2014 within bracket Supra. Full stop. Pursuant to the orders as above, pursuant to the orders of the Honorable Court as above, and also further intervening orders of the Honorable Court, the District Primary School Council, the Commissioner of School Education, filed a Commissioner of School Education, West Bengal, filed a report dated 10th of August 2017, wherein and whereunder it was recommended that a verification exercise be conducted by the chairman district primary school council, Paschim Mednipur, and the panel be recasted in terms of the prevalent recruitment rules, which shall then be sent to the Directorate of School Education for necessary approval. Full stop. Para. One of the aggrieved candidates, one of the general category candidates, aggrieved by the exercise undertaken above, to recast the panel upon verification of individual credentials, moved the Honorable Single Bench by way of WP 16313 within bracket W of 2016, and by judgment and order dated January 11, 2018, which is the order impugned in this appeal, was granted a writ of mandamus protecting his service and also his benefits arising out of such service. First, it would be of use to record at this point the report, another report prepared by the Commissioner of School Education, West Bengal, which has been relied upon by the Honorable Single Bench within bracket Subrata, full stop. The said report, inter alia, states that it has been difficult to verify the testimonials of the candidates in the absence of records from the then appointing authority, the District Primary School Council, Medinipur, which is now the Paschim Mednipur District Primary School Council, and further considering the fact that the appointees have been working in schools for a long period of time, scattered over both the districts of Purva Mednipur and Paschim Mednipur. First, para. Heard Mr. Chatterjee, Leonard, Senior Counsel, appearing for the District Primary School Council, Paschim Mednipur. Full stop. Heard Mr. Maiti, Leonard Counsel. You appear for? Heard Leonard Counsel. Heard Mr. Maiti, Leonard Counsel, appearing for the writ petitioners / the respondents in this appeal. Full stop, para. Having heard the parties and considering the materials placed up to this stage, this court is prima facie satisfied that the respondents are bound to explain. This court is substituted for it. That the 56 numbers of scheduled caste, SC category posts in the said selection have been illegally filled up by general category candidates. Full stop. This court is also prima facie satisfied that the concerned respondent authorities, being the Commissioner of School Education, assisted by the two district primary school councils of Purbo and Paschim Mednipur respectively, have been unable to adequately explain before this court the reasons for not conducting the verification exercise. Verification exercise of all the candidates. Full stop. Para. This court at this stage therefore grants leave to appeal to the appellants and permits, full stop. This court further permits the appellants to supply their individual roll numbers to the learned counsel, to the learned advocate, appearing for the district primary school council, Paschim Mednipur, which was the then appointing authority. Full stop. Para. Upon receipt of the roll numbers,
as available in the admit card, we have been given.
Upon receipt of the roll numbers, the district primary school council, Paschim Mednipur, shall place before this court on the next date the cutoff marks in respect of SC category candidates, as well as the overall position in the merit list with their respective cutoff marks of each of the writ petitioners, each of the appellants, up to the 56th SC category candidate carrying his or her cutoff mark. Full stop. Para. The district primary school council, Paschim Mednipur, shall also produce before this court the একটু দাঁড়াও,
ছাপ্পান্নটা কি করছে?
114. Note for an page 114.
56 additional SC. This should be. This should be 56 additional SC because 56 has been granted with the general. The moment they are out, this is giving birth to 56 additional scheduled caste posts. Because there is a, suppose there is a cutoff marks of up to 50, up to 500.
Let them
There has-
supply. Malad, I am cutting short this. Let them supply their roll numbers. I shall indicate their actual marks obtained by them and what is the cutoff marks at the present moment in 1996 of the scheduled caste untrained candidates.
56 up to the 56th.
To the subsequent 56.
No. I shall indicate the overall cutoff marks in respect of untrained scheduled caste candidates.
Why untrained only? We do not know whether they are trained or untrained.
Because they are untrained. They are not
We do
trained.
not know.
No. It is their case. They are untrained. They are not trained.
Training and training is not a mandate at that present.
Maybe. But training qualification added certain marks.
But you produce the marks for both.
Kindly
trained
let them
and untrained.
ask them to produce the scheduled caste panel.
I shall produce before your lordship the cutoff marks of the scheduled caste candidate in both categories, trained and untrained, and the marks obtained by each of the appellants before your lordship. Then your lordship will apprise that what is their marks obtained and what is the cutoff marks, whether they are eligible or not.
In any event, your general category, you could not have filled them up by general scheduled caste.
Now, Manoj, that is next. If that 56 goes, then the marks will be lowered down. To what extent lowered down? It has to be calculated. It has to be calculated. To what extent it will be lowered down? It's not that it will be that then Manoj, the entire panel is to be checked out. What is the next available candidates are there? Then it will be 96 panel. It will be Herculean task that 1 week or 2 weeks will not serve the purpose. In short, I can do all these things immediately.
We are looking at again the broader question. We are looking at the larger picture also.
I know
we are not forgetting the wood for the trees. Larger picture is ultimately we are looking at a scenario with all your cutoff marks, with all your merit list. That 56, wherever it stands in that position, that 56 belongs anyhow to scheduled caste category candidates.
Yes, Manoj,
So
that
therefore-
56 belong to scheduled. Suppose your lordship
So
kindly.
our effort is to identify that 56.
That's right. Now, if 56 goes, now 56 will be kept blank for the scheduled caste candidates. Now, out of 56 candidates, there are certain percentage of trained candidates, certain percentage will be given to the untrained candidates. Cut-off marks in respect of both the categories have been fixed by the Commissioner of School Education. Now, in respect of cut-off marks, what is their marks obtained and what is the cut-off marks at the present moment? Now, these 56 if gone, now what will be the cut-off marks will be lowered down. Suppose your lordship is asking that this 56 gone, then this 50, then cut-off marks may be gone down by 10 or 15 marks. If they are within this 10 or 15, they will be within the zone. If they are not, they will not be within that zone. As I understood the order by hearing. That is the genesis of the order. That your lord, if the 56 are kept vacant, then what will be cut-off marks is lowered down. Whether they will come within the zone or not. That is the question. Suppose they got to, just now, just in another court I have shown, one candidate got 23, cut-off marks is 47. Under any circumstances, if the post is vacant, he will not come within the zone.
Then we want to see from the general category candidates, how could you fill up the SC post? What
is their marks even?
What is
No.
What prompted them to appoint?
No, the SC posts have been filled up by general candidates.
That's right.
General, admittedly,
What yardstick did you apply to fill it up?
admittedly, at that relevant point of time, trained SC candidates were not available. Trained general category candidate was available. That's why these posts have been filled up. That's why this post have been filled up. The Honorable Court has deprecated that. That has been set aside.
That means, if your lordship,
That has been set aside. That is gone. That is neither here nor there. That is not in the picture at the present moment. Now, if this 56 goes, then these cut-off marks will lower down. Naturally, it will be lowered down. To what extent it will be lowered down, I have to find it out. Whether within that lowered down, they will come within the zone or not. That's the only question. If they come within the zone, they will be considered. If they are not, they will not be.
if I adapt
After
this
lowering the
submission,
cut-off marks,
that means there is no other scheduled caste at this present moment. There was no need to go for all these therefore, what he is on, since there is non-availability of train, there's no, at that material point, training was not a mandate. They chose to implant their own wisdom and appoint all these persons. What I'm on at this present juncture, instead of going all these things, I've got 18% of here. There are 56 available vacancies. Appoint us. That will make the situation more.
Why?
Then situation will be more harsh. Then you have to throw the 56 out first.
What is the cutoff mark for an untrained general category candidate that you have appointed? You have appointed untrained general category also. That time training was not mandatory.
Yes.
That time training was not mandatory.
And you have appointed non-trained.
But your lordship, this honorable court was pleased to deliver a judgment. If the training candidates are available, then 1 minute training candidates will be given preference than the untrained candidates, and 50% post to be filled up by the trained candidates.
Yes, that is the rule. That one. All action.
Which means, was the judgment saying that even that the trained candidates would swallow up scheduled caste posts?
No. That I'm not saying. I'm saying now the trained scheduled caste, untrained candidates were not available within the cutoff marks. Trained general category candidates have been filled up by the better candidates.
You know, we are questioning that if that is not permitted by your rules, we are questioning that. If that is not permitted by your rules of recruitment,
that has not been placed in your lordship, and that has accepted by this honorable court. Now I cannot newly make this argument. It's not possible, and I cannot make, because that there is a rule. If the scheduled caste candidates are not available, post can be converted. There is a rule. Your lordship knows better than me. And my Lord Justice Banerjee is regularly hearing that sort of matters, that the service matters, that the scheduled caste post has been converted to the general category if the post is not available. So, my Lord, that is not the new thing.
No, but here the candidates are available.
Yes.
No.
Here the candidates are available.
Trained candidates are not available within the
There
cutoff
was no
marks.
mandatory training that was required. The scheduled caste
My Lord,
candidates
I shall show to your lordship the 1940 rules, where the training is also a must qualification. In 1940 rules.
No, but we are in 96.
Yes, then 1940 rules was available, not 2001 rule. Because
you give us you share your list first with Mr. Banerjee, and then you give it to us, so that he can respond to it on that date itself. The list you
no. He has to supply us the roll numbers. We will give him the numbers he obtained against each candidate, and if the 56 gone, then what will be the cutoff marks gone down? These two information we shall give it to him.
We meet on the 8th of June.
8th of June. Very well. 8th of June. 8th of June. দেরি আছে তো এক মাস। পরের সপ্তাহে কোথায় হলো?
না।
Let him supply within a short period, because 96 record I have to search it out.
You give him the roll numbers.
Yes.
Give us the can numbers first, then give him the roll number.
Only one thing would kindly add to that. What is the numbers of the persons they have appointed? That is also
no, my lord, that is not required.
Why? We have been suffering. We have been.
He cannot
Raising square so much after doing all sorts of these things. Lordship is already taking a zero tolerance policy as regards this corruption is concerned. What more is corrupt? More is corruption.
He cannot enlarge. One after another, he cannot enlarge.
This is my petition. I can ask for.
My petition লাগানো নেই।
Look, kindly appreciate. They have to give this. What is their numbers?
Post 56 general category.
56 general categories.
That I have give, that I shall give, I have already
That is-
indicated.
56 general categories. Those.
Note টা করে, no?
They have inducted themselves as scheduled caste. Let us also know.
No, that 56,
Let us also know 56 general
candidate
categories.
to whom the appointment has been given.
Yes.
Obviously, they are better candidates.
Let us see how much better they are.
Obviously, they are
Therefore,
better.
why they have been gulping the shares of
Obviously, they are better candidates.
Let us
They have not spelled a single word against this person that they have not qualification.
Because at that development quarter, class 8 pass can be appointed. Private teacher under 1942. Class 6 was appointed private category as a primary teacher. But in case of general, minimum qualification is not given.
School final.
School violence, and then the 50% reserved for the training. See that.
that prompted them to gulp the scheduled caste force.
That law, I said, what is the intent? Yes, because the parents started here 1980. That is, I, what is
Mr. Banerjee, you are making a mistaken assumption. Not everybody has the same appetite. Somebody can gulp more, somebody cannot gulp.
They are gulping more. What can we do?
We are getting the statistics first and then we will.
Very well.
8 June, 2 p.m.
2 p.m.
Thank you for a very spirited
Grateful. হ্যাঁ দিয়ে দেও একটু মিলিয়ে এই গৌরদা এই নাম্বার গুলো একটু মিলিয়ে নাও না তুই যা গৌরদা তুমি নিয়েছো তো কে নিয়েছো এই একটু মিলিয়ে দে নম্বর গুলো না মিললে কিন্তু গন্ডগোল হয়ে যায়